May I have my lords kindly to mention a matter for inclusion in my lords list, my lord. This is the Birla Corporation, my lord, incentive scheme revocation bill matter, my lord, by an order of 5th August. Grateful.
May I speak for your lordship? Leave to file an urgent application. This is a matter of senior citizen, my lord. The petitioner is a mother of 68 years old, my lord. It has been not maintained by his son, my lord.
You want leave?
My lord, to file, my lord, is urgent, my lord.
What is the order of the tribunal?
Lord, she has referred to the tribunal, but no steps have been taken as I have instructed. That's why, my lord.
No steps taken by the tribunal?
Yes, my lord. She has made the...
You want early disposal of your application over there?
My lord.
Is this your prayer?
My lord.
And for that urgent hearing?
Yes, my lord. She have preferred the application on, my lord, 19th. Perhaps there was that time holiday.
Then file it in the department.
Your Ladyship, may I be permitted to mention a matter? These are the incentive revocation matters.
Yes.
Your Lordship, I'm praying for upgradation so that the matters can be fixed on some date.
No.
Your Lordship, the petitioners have challenged the Incentive Revocation Act.
Yes, I am aware of it. But then no upgradation. It is due to appear when? 7th?
No, Your Ladyship, these matters are in the list. They've not been heard even once. So we just...
Doesn't matter if the hearing takes place and whatever order is passed, same order can be passed. No,
Your Ladyship, if this could be taken up with the batch.
Lordship,
Yes, please.
Lordship.
My Ladyship, with my lady's kind permission, my lady. My lady, I'm appearing through VC, my Ladyship. My lady, I'm requesting my lady for an upgradation of 2 urgent matters. My lady, we have moved these matters before my lady prior to vacation bench. My lady was kind to allow these matters to be listed before the vacation bench. But due to some paucity of time, my Ladyship, the matter couldn't be taken up. My lady, I'm in a grave urgency. My accounts have been freezed, my lady. My entire business is dependent upon cash, which is not feasible for me to run it on a day-to-day basis. My ladyship, I'm running a diagnostic center. The bank has, my lady, without giving me
what do you want?
My lady, I want my matter to be upgraded and listed. It is in a monthly list, my ladyship. These are 2 matters, my lady.
The matter is right now not in the list.
No, my ladyship.
Please pass on the numbers so that it can be listed.
So deeply obliged, my ladyship. My ladyship, so deeply obliged.
Yes.
May it please your ladyship.
Is this the first day?
This is the first time, my lord, I will be praying for issuance of a rule of contempt because the contemners, through the learned advocate general, my lord, has given an undertaking.
Already served copy. Please come.
My lord, kindly hear me, my lord. It is a fit case, my lord, for issuance of rule, my lord.
The AG was appearing. No rule is required. You serve and come back. First day the order today is 29th. Make it returnable on the 12th of November.
But service upon all the alleged contemners.
Yes.
But grateful to your lordship.
I am appearing for the respondent number 4.
I'm appearing for respondent number 1.
I appear for the petitioner. My lord, I had filed this writ petition, my lord, because my lord, I'm a lady, 55 years old. My name in the civil report, my lord, showed drastically low figures. I called upon them to stay on what basis have you given me such low figures. Then I was told, my lord, that various banks and financial institutions had taken loan from. In fact, I have not taken any loan. Then I filed a writ petition, my lord. When the writ petition was filed, the matter was moved before my lord, and the my lord directed them by an order to disclose the basis of these banks being made as my creditor. They did not file any document, they filed an opposition, my lord. In the meantime, my lord, the latest civil report showed all these bankers' names had gone, except one entity, PayU Finance, my lord. The respondent number 4, now they have restricted their case to PayU Finance. On the last occasion, on my lord's direction, someone appeared for civil. They handed over a bunch of papers to me, saying that these are the documents, without filing an affidavit. Now, when I took it, my lord, last order records that I shall go through the document which is given in court. When I see these documents, I find, my lord, The person whose documents have been forwarded to the court is bearing the same name, Sunita Gupta, which is a very common name. This lady lives in Delhi. I live in Calcutta. This lady, date of birth is 1999, which is 26-year-old. I am 56 years old. Well, I today humbly submit, let someone take this responsibility, let them file this on affidavit before my lord. Then I'll deal with this, my lord. Sybil had given me this yesterday on the last occasion, my lord. Let someone file this on affidavit, my lord. Because this is not me, my lord.
Let me see the papers.
Yes, ma'am. All other names have been removed except PayU Finance.
No, not this. Did you hand over a set to the court? Yes.
I can give a copy, my lord.
No, just wait.
Yes, this document, my lord.
Is it
Kindly
this?
comes to page number 4, my lord. We'll find the date of birth. Page 4.
Yes,
Bottom
99.
name Sunita Gupta, 1999.
Yes.
My affidavit, my lord, will show I'm 55 years old, my lord.
Alright.
Then, my lord, the address. Next page, my lord.
Delhi.
Delhi. I have never resided at Delhi. I'm a housewife, my lord. So this is not me. Let them file an affidavit.
Sybil, you are relying upon this document to.
These are the documents which were forwarded by PayU Finance and several other documents I filed on the last date, my lord.
No.
Several other entities, my lord, on the basis of which this report has been updated, my lord. Now, Sybil has no business, no nothing to do that, to make a.
No, but then these documents were forwarded to you by PayU.
Yes.
You get in touch with PayU because check up the petitioner's credentials and you match it with whatever you submitted and see if there is any discrepancy. Please rectify it.
Provide a copy of loan agreement because I would have signed a loan document if I had taken the loan.
All right.
I'm for the pay for you.
You are there for PayU.
Yes, my lord. I am pay for you, but no copy has been served upon me, neither of the petition or application.
It has been served. My land friend is appeared for the first time today.
Very well.
I'll give them a copy.
Very well. Take instructions.
Well,
please do.
Also, my lord, the Sybil should file an affidavit.
Has Wakalatnama been filed?
No, my lord, because no affidavit, no copy. I have not the first title. That is the only reason.
What is your name?
I have given my name.
You've given your name. Learned Counsel. All right, all right. All right. Learned Counsel
Copy.
representing PayU Fin. Respondent number?
PayU finish 4, my lord.
Finance India Limited. Respondent number 4.
PayU Finance.
Enters appearance and submits that the copy of the writ petition has not been received by his client. Stop. Let a copy of the writ petition be served on the learned advocate for taking necessary instruction and also for filing the Wakalatnama. Stop. Learned advocate shall apprise the court as to whether the documents relying upon which the Sybil score of the petitioner stood reduced actually belongs to her or not. How soon can you come back?
15 days time.
18th of November.
My lord, will it be my lord's pleasure to direct the Sybil also to file this affidavit because they have, my lord, given this before the court, my lord.
Sybil relied upon
Very well, my lord.
PayU's. Now,
Anyone
if
should file.
if
Very
PayU
well.
comes, then your problem will be solved.
Very well.
Grateful to watch. আচ্ছা এসিটা কি চলছে? এসিটা গরম রয়েছে না?
She was asking, is there any rules of under-valuation rules or things? Lordship?
There is, but
That's
then
the rules,
how you make it applicable here?
এটা বের করে যাচ্ছি rule 3, Lordship. I'm just handing over it. Rule 3, Lordship.
Yes.
C1. The market value within the meaning of clause 16b of section 2 in relation to any land or any land with building shall, after taking into consideration the particulars referred to in subsection subrule 2, be determined on the basis of the highest price for which sale of any land or any land with building of similar nature and area and in the same locality or in a comparable locality has been negotiated and settled during the 5 consecutive years immediately preceding the date of execution of any instrument setting forth such market value, or on the basis of any court decision after hearing the state government, or on the basis of information, report or record that may be available from any court or any officer or authority of the central government or the state government or any local authority or local body, or on the basis of consideration stated in such instrument for such land or land with building whichever is greater. Lordship 2. Any person executing an instrument of agreement or memorandum of an agreement relating to a sale or lease cum sale of immovable property, conveyance, exchange of property, gift, partition, power of attorney, where proper stamp duty is payable on the basis of market value, settlement, transfer of lease by way of assignment shall furnish to the registering officer in addition to the particulars referred to subsection 1 and subsection 2 of section 27 such particulars in respect to the property as may be applicable to the property and as specified in statement in form 1. In case the land with building is situated in urban area, in form 2 form has been issued. In case of land is situated in a rural area. Lordship, kindly turn Lordship page 7, Lordship.
Yes.
On receipt of any instrument referred to in subrule 2 in relation to a property together with the statement in form 1, form 2, form 3 or form 4, as the case may be, annexed thereto, if the registering officer has reason to believe that the market value of the property has got been truly set forth in such instrument, he may make such inquiries and take into account such court decision, information, report or record from any court or any officer or authority of the central government or the state government or any local authority or local body or any person having knowledge relating to market value of the property of similar nature and area and situated in the same locality or in a comparable locality as he deems fit for ascertaining the market value of the property and proper stamp duty chargeable. 8. On the basis of inquiries, court decision, information, report or records referred to in subrule 7, as the case may be, the registering officer shall ascertain the market value of the property and shall pass an order in writing to the effect in form 1, 2, 3 or 4, as the case may be. And if he finds that the market value of the property is more than the has been set forth in the instrument referred to subrule 2, he shall keep the registration of the document in abeyance and shall issue notice in form 5 communicating the person by whom the stamp duty is payable under section 29 or his authorized agent or authorized advocate the amount which he believed to be the market value of such property and calling upon him to make payment of the deficit amount of stamp duty within the period of 30 days from the date of receipt of such notice. The registering officer shall record the particulars of such documents from private. Lordship, nothing has been done. Alternatively, Lordship.
Yes.
Lordship, they have not done nothing, Lordship. Alternatively, Lordship, in terms of court order, when hearing took place, we have placed a deed of conveyance of other person in the same area, same locality, adjacent to that building, that to show the valuation was going on at that time.
So a hearing was conducted. A hearing was conducted.
Hearing conducted as in terms of the court's order, Lordship.
Yes.
And after 17 years, of course. And in Lordship, we have submitted one deed of conveyance of the same locality, which was registered in 2011 on something else. And the valuation shown, we have relied that valuation, but they have not considered it. Lordship, let's see the Lordship, they have accepted that we have submitted this.
They have accepted means it is reflected in the order sheet.
Lordship,
The impugned order, is it reflected?
no, Lordship, not. They have accepted it in their affidavit in opposition.
Yes, in their affidavit in opposition. All right.
Page 14, Lordship.
Let me see the opposition, please.
Lordship, it's a form of report.
All right, the report.
Did you give the affidavit in opposition?
Yes.
Compliance.
Which
No, compliance report.
Compliance report.
Contempt, Lordship. At the time of contempt, Lordship, this is compliance report. I'm
Is
sorry.
it not a part of
That
the
is the part,
petition?
Lordship, that is the court record, Lordship. Because they have filed it before the court.
Yes.
Copy করে আছে। এ থাকবে না, the compliance report. Lordship, the right hand side, Lordship, they have received the documents we have relied on that has been mentioned.
Attendance sheet, name, signature, reference number, date. This is an attendance sheet. This is how it is marked. You have a copy?
Lordship, I do.
See, it is mentioned attendance sheet in respect of such and such, name, signature,
And right hand column, Lordship,
reference name and remarks. Photocopy of the deed of conveyance.
Lordship. We have produced it at the time of hearing. That they have produced before the at the time of
Calculation
compliance
sheet in
report
respect
of
of
the
18.
contempt application.
What is the address of this property?
Lordship, Lordship, this address is 18, Lordship.
Richie Road?
18, this is 18 and we are 16. Petitioner is in 16 and that is on 18.
All right, calculation sheet in respect of 18 and 16 Richie Road. Rent receipts for each tenant.
Lordship, our property is fully tenanted, that property is also fully tenanted.
Tell me, who are you? Are you the purchaser?
Lordship,
You are the purchaser. All right, yes.
so that procedure they have not followed, Lordship. Lordship, they have not followed that procedure
All right.
and they have not considered anything, Lordship. That we have, Lordship, we have also, Lordship, submitted the valuer report, Lordship. Of course, it's a private valuer report, but that has been, I have annexed, Lordship, in my affidavit in reply, Lordship. Valuation exception, please,
This is a point not taken in the writ petition. I'll address it.
Which one?
This point that under-valuation rule was not followed by us. This is not a ground in the writ petition or any averment to that. So I can, otherwise I would have produced not the documents to show. Anyway, my lord, I'll.
No, you must be having your circle rates and everything as to how you could
But
assess.
only one thing, 2007, when the document was produced, not under-valuation rule was there, but not the COD rules, computerization of registration of document, COD rule was not implemented. So possibly circle rates were not there, but the procedure, rest of the procedure was there.
All right, let it be.
Lordship, nothing is there, Lordship, because they have not spelled out how in that affidavit, Lordship, that how they have calculated that amount. Forget about the report they have submitted, forget about the reassessment order. They have not explained anything. How, what is the basis, Lordship? They have not explained in their affidavit also. That what is the basis by which building or land they have assessed, or the basis of the order is such and such, nothing.
All right then.
Lordship, we have also annexed a valuer report, Lordship, my affidavit in reply, page 24.
Yes.
Of course, Lordship, is a private valuer report, but it's
All right. What exactly has the authority disclosed in the opposition to arrive at such an assessment? Nothing.
Nothing.
All right.
Lordship, valuation sheet, Lordship, valuation report.
In the reply?
Lordship, page 24.
Exception by the petitioner. Yes.
Lordship, Dilip Kumar Datta, Sarbojit Datta, chartered engineer and valuer, government registered valuer.
24.
24.
Sarbojit Datta.
Yes, Lordship.
This is the wealth tax registration as valuer.
Approval valuer of banks, approval valuer, Honorable High Court, Calcutta. Lordship, he has valued the property, Lordship, at page 26, Lordship, considering everything, structure and other things. This is the valuation report we have submitted also.
34 lakh.
Lordship.
Right. And what was your set forth value?
36.
36. And more. All right. And what is the valuation assessed?
Near about 3 crores.
3 crores.
Land in Vichy Road.
That is also 8 car lordship I have handed over. And that is also fully tenanted, Mike also fully tenanted lordship. Lordship 131 start, 132 lordship valuation.
Hmm. Yes. Anything else?
Lordship, I have on to realize another judgment lordship. EIR 1998 Allahabad 237.
Hmm. On which point?
Lordship, the point is that lordship the 3 points was held. এটা হচ্ছে অনলাইন কস্ট টাইটেল দেখে না Oh, 237. Lordship, it's a point was while accessing power and lordship. I'm sorry, lordship. The point raised there that it was content last 3 lines. It was contained on behalf of the applicant that the instrument having been registered on February 1, 1989, the proceeding initiated by the collector on May 26, 1993, were beyond limitation and further in proceedings of support. So limitation period whether it is mandatory or not, lordship. Lordship, 2-3 points have been framed, lordship. I am not troubling your lordship. Page 6, lordship.
Paragraph 6.
Paragraph 10, lordship. Page
Paragraph
6.
10, page 6. All right.
There is no dispute from either side that the starting point of limitation is the date of registration of the instrument and the period of limitation is 4 years. According to London Chief Standing Council, it's if a reference from any code or commissioner of stamp, additional commissioner of stamp or duty commissioner of stamp or any other officer authorized by the board or revenue in on that PF is made within 4 years from the date of registration of the instrument. Whether any action is taken by the collector or not, the proceedings would be within limitation. Since Rajiv Joshi Learned Counsel for the applicant has, on the other hand, counted that a limitation of 4 years for the collector to initiate action and the date on which a reference is made by court or authority enumerated in the opening part of section 447A is irrelevant. The question which arises for consideration whether the period of 4 years qualifies the action of collector or the making of offence under subsection 147A of the registration record. I am skipping para 11. It may be noticed that the language used in opening part of subsection 4 of section 30 is exactly similar to the language used in the opening part of subsection 4 of 47A. The provision of subsection 5 of section 30 says no action under clause subsection 4 or subsection 5 shall be taken after a period of 4 years from the date of execution of the instrument. Here the bar of limitation applies to the action which may be taken by the collector, not to a reference. There is no reason why similar interpretation should not be given to subclause 4 of section 47A. Specifically, when both the section, namely section 33 and 47A, find place in same chapter, that is chapter 4 of the Stamp Act. It has been held by a full bench of 7 judges of the Honorable Court, such and such and others, that where there is some doubt or ambiguity in any provision in the authority's English text, it is not Hindi text is they are relying. My contention is that that period of limitation is mandatory, which has been held. That this limitation has to be followed.
Hmm.
And Lord, I shall rely another judgment of Madras High Court 1997 volume 2 CTC 190. তোমাকে একটা কপি দিয়ে এটা পাবেন হয়তো। Lordship, para 13, state page. We have already seen that the sale deed in question was executed on 3/85. Therefore, the collector can invoke his suo motu jurisdiction under section 47(a)(c) of the Indian Stamp Act within 2 years. Lordship, that is 2 years for Kerala Lordship. In this case, the collector has initiated probably by issuing a notice under section 47(a)(c) only on 15/5/1991. Therefore, as rightly pointed out by the learned counsel for the petitioner, the proceeding initiated by the collector is after the expiry of the period allowed by law to initiate the proceedings under section 47(a)(c), and such the proceedings are barred by limitation. So my contention is that the procedure they have adopted is barred by limitation. Lordship, come what may, whether it's a power of collector, sub-register, or additional register, but when the time frame has been given, that is mandatory. After that, they cannot initiate any proceedings. Lordship, I have relied judgments on 2 points, Lordship. First point, if there is no basis for reassessing the property, no basis at all. They have to show basis, they have to give reason, Lordship. Nothing has been given. And number 2, Lordship, the limitation period, they cannot act beyond the limitation period. Lordship, my learned friend has, in his affidavit in reply, Lordship, has pointed out 2 things. Lordship, I have stated that first thing is that it was also our duty to approach the authority, and we have left not to approach the authority. This is the first point I have dealt with. And another point, Lordship, there is a appealable, this is the appealable order. So we have not preferred appeal. This writ is not maintainable. Lordship, your Lordship knows that the Whirlpool Corporation judgment, Lordship, that is well-known judgment. I am relying the Whirlpool, Lordship. Judgment reach. Para 14 and 15.
But will you qualify within 14 and 15?
Got.
Please show.
Has the Lordship got it?
Yes, yes.
Power to issue prerogative deeds under Article 226 of the Constitution is plenary in nature and is not limited by any other provision of the Constitution. This power can be exercised by the High Court not only for issuing deeds in the nature of habeas corpus, mandamus, prohibition, quorum, and certiorari for the enforcement of any fundamental rights contained in Part 3 of the Constitution of India, but also for any other purpose. Under Article 226 of the Constitution, the High Court, having regard to the facts of the case, has a discretion to entertain or not to entertain a writ petition, but the High Court has imposed upon itself certain restriction, one of which is that if an effective and efficacious remedy is available, the High Court would not normally exercise its jurisdiction. But the alternative remedy has been consistently held by this court not to operate as a bar in at least 3 contingencies, namely where the writ petition has been filed for enforcement of any fundamental rights, or where there has been a violation of the principle of natural justice, or where the order of proceedings are wholly without jurisdiction.
Which one do you qualify?
So only without jurisdiction. After a limitation period, they cannot act, Lordship. And more so, Lordship, I have stated also that the documents we have relied on, they have not deal with that. They have not considered with that. That is not a reason order. So violation of natural justice is also a point to be noted, Lordship. And Lordship, I am relying another judgment, Lordship. Lordship, I have only one copy. That is the book, Lordship. Calcutta High Court Division Bench, Lordship. 2001, Volume 4, LLG. Page বলে দিচ্ছি 1 to 1. Lordship, I'm just first 1 to 1 page. LLJ, page 1 to 1.
Give me the citation once.
Lordship, 2011, Volume 4,
Yes.
LLJ, page 1 to 1.
Give me the citation. The name of the parties.
Lordship, Paramount Leathers versus Regional Provident Fund. Paramount Leathers.
All right.
Versus Regional Provident Fund Commissioner and others, Lordship.
All right.
Lordship, I am relying para 25. Lordship, just first I shall read out, Lordship, then I shall hand over. we are of the view that the order, it is a division bench judgment, Lordship,
All right.
that the order includes the writ petitions is one such where the deed jurisdiction should be invoked. We have already seen the nature of the order. It is not merely a wrong order. It is an order while passing which the authority clearly failed to exercise its jurisdiction seen in the perspective of the requirement of the test to be applied by a statutory authority. The authority in section 7A of the Act is required to decide the dispute of applicability of the Act to an establishment. The order passed was not a speaking order. It's also, it narrated the respective cases of the parties and without anything more formed its opinion that the two firms were in fact two units of a single establishment. This ought to have been preceded by a discussion of the materials on the basis of which the conclusion has been drawn. There is no factual substance in the arbitrarily arrived conclusion. A finding of fact without any evidentiary backup is a perverse one. Equally, the Honorable Supreme Court relied judgment has retired a very well-known ratio that the administrative and judicial orders must be supported by reason. It has further proceeded to hold that recording of reason is a principle of natural justice. So, why I am saying that the principle of natural justice is because there is no recording or order. Lordship, see the order, Lordship.
All right, I'll see it.
Lordship, so this is my substance of my argument. Lordship, 4 point, Lordship, registering authority did not follow the rules.
Yes.
Lordship, time limit, this is the essence of that. No reason has been given. And Lordship, I have shown that there it should be must be an order that defect, rejected or defective.
All right.
That is not also they are not neither
Right.
in the record, now none they are.
All right. All right.
This is my
Yes.
Not the submission made today does not go in sync with the case made out in the writ petition. In the writ petition, my lord, the petitioner has challenged a Form 5 notice. If your lordship kindly takes up the impugned notice at page 131,
Yes.
this is under challenge. This first pair, second pair is that it should be assessed as per the set forth value. That not is on the basis of the submission that it is barred by limitation. Now we cannot invoke 47. These are the two submissions made. 131, if your lordship takes up the undervaluation rules, my senior friend has already placed section rule 3, subsection 7, that Form 5 notice has to be issued. Kindly comes to Form 5 to that rule, my lord. Subrule 8 and corresponding Form 5. May I find out for your lordship? Lordship, take my copy. Kindly see this form, my lord, and the notice given, page 130.
Yes.
Exactly, my lord, in the
It's
form.
a notice.
My lord.
It's a notice.
Absolutely in the form which is prescribed, my lord, notice has been given. He is challenging only this notice. Market value, pay it, otherwise we shall send it under section 47A.
No, but then whether you could have issued this notice after so many
After
years.
so many,
This
yes,
is
I'll
3
deal with
years.
that. I'll deal with the provisions not my senior friend has quoted to show that there is no period of limitation prescribed. He has quoted some provisions. I'll go back to that. So this is a Form 5 notice which is issued absolutely as per the form provided in the statute. Now, my senior friend has relied on, firstly, section 33 of the Stamp Act, West Bengal Amendment. Section 33 West Bengal Amendment, that after 4 years no action can be taken. If your lordship sees section 33 is not impounding of documents, starts with every person by law or consent of parties authority to receive evidence. And every person in charge of public office except an officer of police before whom instrument chargeable in his opinion with duty is produced. So this is a case not of impounding of documents. When a document is produced, unstamped document, there's a line of judgments.
So this is not applicable.
This is not applicable at all. Here, there's a West Bengal amendment which says that this cannot be done after 4 years. This has no applicability at all. Then, he has relied on section 47A8. 47A8, there's a suo motu power of the collector. 47 capital A, subsection 8. This says the authority referred to in subsection 3 may, on receipt of any information or otherwise suo motu within 5 years from the date of registration of any instrument.
So this is also not applicable
not
because it has
applicable.
not been
And the
registered.
authority, who is the authority? I am the notice issuing authority is not the authority. Because I'll place the scheme of the section. First, my lord, the registering officer, if he has reason to believe, then he will record that in the form submitted by them and then issue a form 5 notice. 40, this first step. Then, as per the assessment, he will ask him to pay the money. If he does not pay, then it shall be referred to the authority. Now the authority will adjudicate, he has a right of hearing. That stage has not yet arrived. He has challenged at the notice stage. Now, so subsection 47A(8), firstly, for authority has, collector has not yet adjudicated. He has not paid, he has directly come to the court. And secondly, this is after registration. The suo motu power is 5 years from date of registration. So 47A(8) also is not applicable. The rest of the provisions are section 52 of the Registration Act, which is duty of the registrar to register, subject to the Act and rules. Now, the registration, this power is not subject to the Act and rules. Rule 123, 124 of the West Bengal registration rules prescribes the procedure of payment of the stamp duty as enter stamp duty upon which the document shall be registered. So presentation does not mean automatic registration. So for 52 will not debar me from exercising 47A, or it does not impose any limitation also. And section 71 and 72 has been relied on, which is refusal to register. There is no order of refusal passed. We have not refused. We have only said that this is the valuation because we kindly consider it. It's about 8 kata, 7 chatak land in Richie Road, surrounded on 3 sides. One side.
How did you assess? Tell me this.
But
on what basis was the assessment made?
Now,
because the difference is huge.
Not the assessment. Yes, difference is huge because not in 2007 also a huge land in Richie Road. It is not a exorbitant figure. 2 crores and not 2 crore 96 lakhs.
And then this document has been relied upon by the petitioner in respect of the adjacent property.
They did not call for the order which was passed because the rule says that they will submit the particulars in a particular form, form 1, form 2, form 3 or form 4, whatever is applicable to their case. They will submit that. Now after that, the registering officer will record. If he is dissatisfied, he will record his reasons and then issue form 5. So they are now asking, in the writ they have not said that. Now they are asking for that recording. That recording with the registering officer based on which form 5 has been issued. That was, it was not a case made out in the writ petition. I can ask the authorities to bring the file. They can show it to a lordship. There has
no, in the opposition, have you disclosed, opposition or report, whatever you have filed, have you disclosed anything as to the basis of the assessment? The court wants to know this only.
No, in the affidavit we have not disclosed because they have not taken the point that prior to form 5 notice, which is under challenge, no order was passed. That is not the specific case made out because before form 5, opinion was formed. That opinion is not under challenge. If your lordship, if he wants that, I can produce the opinion form. After the opinion form, notice is issued. After this notice, there are 3 stages. First, my lord, after the opinion form, notice shall be issued. You pay this amount. If it does not pay, then it shall be referred to the collector. Before the collector,
those are later stages.
Later stages.
But the formation of opinion must be relying upon certain documents. What were those documents?
So then the
How
record,
could you?
I can produce the record. I had a talk with the registrar also. He says that not the reason.
See, I can remand it back, but then if
I
you
can satisfy your lordship.
yes, if you can satisfy, then it can be finished here.
Produce that on Monday or tomorrow because this was not the case. Now he is making out a case that there was no formation of opinion. That is not the case made out in the writ petition.
What is the prayer in the writ?
There is not the notice is under challenge. Kindly comes to page 20. They are treating it as an assessment order. This is not an assessment order.
This is not an assessment order.
The notice.
Yes.
And that is also not an assessment order. That is the formation of opinion. Because before that,
relying on this opinion, only the assessment has been made and payment is to be done.
Yes. On this opinion, yes.
On this opinion. So assuming it is not an order, but then it is akin to a direction, relying on which the petitioner is to
there
act.
has to be some basis.
There has to be, and certainly
But
there
in the
is.
their main case is that after 17 years, this power cannot be invoked. That is the entire tenor of the writ petition. That after, so I have shown your lordship the provisions. The provisions never, my lord, give any particular period of limitation. That within this, it has to be done. Otherwise, 47A power is gone. So his second prayer that it has to be as per set forth value and not the market value. That, my lord, cannot be allowed, because even if today your lordship holds that there is no formation of opinion, my lord, then also he does not, my lord, get away from the rigors of section 47A. He has to pay as per market value. His main intention is, my lord, today if it is done, my lord, I'll come back with the opinion and today's value also, my lord.
All right, that will be all right.
Because
What is passing through the mind of the court, I'll disclose so that both parties will be able to address the court, that the property should not be registered undervalued. Nothing more.
my lord.
What will be the assessment? It is your prerogative. You assess it.
Absolutely.
Now, the petitioner relies upon a document registered conveyance in respect of the adjacent property and says that it was valued at such and such. Mine is valued at such and such. How could there be such a lot of difference?
At that stage, he's getting a hearing, producing document stage has not yet come. Because at the time of formation of opinion, no hearing is given to him. So he is saying my document produced is.
He was present. What did you do on that? The assessment
The court directed not
for an hearing.
We have
Then
given a hearing.
what is the hearing for?
That-
There, the hearing must be for a particular purpose. You just do not go there, sign document, and come back.
I'll produce
Right.
not whatever order has been passed, because prior to the notice, not some formation of opinion
Has to be there.
It is there. It is there. I'm told it is there. So we will produce that. But they have
And
not
please
made any endeavor, my lord, to get a copy of that also. And we are not bound under the statute to give that. We have to give the Form 5 notice. Because subsequently he has the right of
Learned advocate for the
adjudication
petitioner
for the
concludes
collector.
argument. Stop. Learned advocate representing the respondents commences arguments. Stop. It appears that the basis on which the assessment of the petitioner's property was made is nowhere disclosed in the report filed by the respondent authorities. Stop. An opportunity of hearing was granted to the petitioner, relying on which assessment of the property was made and the assessed value was communicated to the petitioner for payment. Not communicated, but intimated to the petitioner for payment.
Under Form 5.
Under Form 5.
The 2001 rules.
There is not mention
Of
at
the,
Form 5.
it is not mentioned,
It is not
but
mentioned.
then it is
Your argument, Lordship, I shall.
in line with the form. In line, in কি বললাম
In
ওটা?
line, Lordship, that is true.
No, it is not mentioned. আগেরটা বলুন।
On which the assessment of the property was made and the assessed value was intimated to the petitioner for payment.
For payment in line with Form 5 of the 2001 rules.
Prevention of undervaluation of instrument rules.
West Bengal stamp, bracket open, prevention of undervaluation of instruments, bracket close, rules 2001. ঠিক আছে? The stop. Without the opinion of the authority. Now, without the basis on which the assessment was made, it will not be possible for the court to adjudicate the issue effectively. Stuff. Next. Hearing of the writ petition accordingly stands adjourned till 11th November. Stuff. Learned advocate representing the state respondents shall produce the basis relying on which the property of the petitioner has been assessed.
11 to which one? Lordship, fixed is on 11th November.
11. I'm grateful, my lord.
Lordship, the deed I have submitted, Lordship.
You can take it back. After deed,
For Lordship, you can keep it in. Copy is there.
দেখে নিন যদি কেউ থাকে
My lord, I beg to appear on behalf of respondent number 1.
Petitioner.
No, my lord. Respondent number 2 and 3. My lord, on the last occasion, I have submitted the report, my lord. It has already been circulated.
What is the matter about?
Yes, yes. My lord, the petitioner complains of that he forging his signature, bank accounts have been opened, and 7 loans
The
have been.
answering respondent is the bank.
Yes.
Bank and the income tax authority also.
Income tax authority.
The last respondent.
Who will be representing the income tax authority?
Nomenclatures are not clear, my lord.
State or
Union of India has not been made party.
no, 5. Union of India is a party.
Party?
Leave granted. That
Leave granted after the leave, yes. No copies have after that, so I missed it, my lord. Extremely sorry.
just put a note. Respondent number 5 is the Union of India, the added respondent. Otherwise, you will have the same problem next
My lord,
time.
my lord. I will just.
None appears on behalf of the petitioner at the time of call. Stop. The respondent numbers 1.
I'm 2 and 3.
Respondent numbers 1, 2, and 3 are represented. Stop. List on 10th November. Let notice be served upon the non-appearing respondents.
My lord.
Next. Is there a resolution today?
Yes.
No adverse.
Why? No adverse orders to be passed.
In absence of either of the parties.
Either of the parties. Yes.
New invent.
Yes, something which was not there in the High Court ever.
No invents are being made.
Yes.
Item number 5, I'm appearing on behalf of the petitioner.
In this matter, I'm appearing for the respondent. I'm being led by Mr. Mahendra Prasad Gupta. He is on his legs, Lordship.
All right. Now, what is the matter?
Lordship, if my lord recalls, a tender was issued and the entry time, the tender had to be lodged by 2 p.m. and one party had lodged it beyond that time. We had also annexed the register book which had shown their entry time, which was beyond 2 p.m. So for that reason, and my lord had directed to file affidavits. The affidavits are complete, Lordship, and the hearing has to commence. I'm led by Mr. Bikash Ranjan Bhattacharya. He's on his way, Lordship.
All right.
My lord, I appear on behalf of the respondent number 5. My lord, I was being led by Mr. Kaur. My lord, he's in some difficulty, your lordship. I was praying that let the matter be taken up tomorrow, my lord.
Tomorrow is a holiday, isn't it?
Tomorrow is a holiday.
My lord, Friday, my lord.
All right, I'll just make it not today.
Grateful.
Great, my lord.
But after the petition. Yeah, the petition.
Non-prosecution.
Lordship.
Any written instruction given? All right, not pressed. Dismissed as not pressed.
Lordship, I'm opposing on behalf of respondents 2 and 3 bank. Time for the petition. I had taken a loan which had they have marked it as NPA. Now thereafter, my lord, they put up a sale notice. We had taken out an application before the DRT challenge.
You moved before the vacation bench?
We intended to, but the matter could not be taken up. Leave was granted.
No,
My client, my learned friend sought for time before the.
right. It is recorded on the prayer of the petitioner.
I'm mistaken.
It has been placed before the regular bench.
That is, and one only thing that we have thought for is, my lord, our right of redemption. And we are intending to pay off the entire due, whatever they have calculated. If they intimate us the amount, my lord, we will repay the entire amount.
What is the stage now?
The stage is they have section 14 order has been passed.
Section 14 also
Order has-
passed.
Possession yet not yet taken physically.
Maybe. But then what is?
You had
17 application has been preferred.
What is?
Already the client of my learned friend has preferred section 17 application in
Oh,
the PRT
section
number 3.
17 is
Yes.
there.
Yes. The filing of the writ petition is the abuse of the process of law. Supreme Court has categorically deprecated the practice of filing writ petition.
I understand, Mother. Nobody is disputing that. All the time, the entire purpose and object of 2002 Act is
How
to.
much is due?
I'm ready with the check.
Not only sale certificate has been issued.
A sale certificate
Yes,
also
yes, yes,
issued.
In the
How
month
come?
of April 2025.
How come
At
that be
this
done
stage.
without serving notice upon me?
No, then you are there before the section 17 court.
My possession has been done. I have annexed page 76.
No, it doesn't. Possession has got nothing to do with the sale certificate.
Yes, my lord.
No,
That's,
no.
once,
You go before the tribunal. Get it
for my
done.
satisfaction, my lord.
No. It
My lord,
cannot be done.
my lord, let them produce the certificate. They have not disclosed anything.
How that helps you?
My lord, I say, my lord, they are submitting something incorrect information. Possibly he has not been instructed
You are
with the
there
facts.
the section 17 forum.
My lord, section 17 forum, I have
Where?
1 minute. 17th application I have filed challenging that initial notice. Now, my lord, without disclosing that, they have obtained an order from the magistrate. They are supposed to disclose that in affidavit, that whether any litigation is pending. Therefore, first submission is that is vitiated by fraud done by the bank.
Challenge the order.
I have the remedy. I'll do that.
Yes.
Now, my lord, bank today is saying that they have sold out. Let them disclose that these are the particulars so that I can challenge there. Let them disclose on affidavit, 1-page affidavit saying that on that so-and-so date, by this notice, they have done this.
All right. I'll direct them to intimate. You challenge.
No,
them
not intimation.
because this court is not adjudicating it.
My lord, let them not say on affidavit. I have come up with an affidavit, my lord. Let them say 1-page affidavit saying that this they have done. Then, my lord, if I have no case, I'll not make any submission. I'll go there.
You do have a case, but before the section 17 forum.
Let me, my lord, have a look to that, my lord. I do not know what they are saying.
Bring the sale certificate.
Yes.
The sale was on public auction?
Yes.
Public e-sale?
Notices.
The auction sale notice was published.
Everything was there.
Has been done.
The notices and the sale certificate.
Just disclose it. Please come.
With my records, my lord.
The petitioner is challenging the steps taken by the secured creditor to sell off the secured asset under provisions of the SARFACI Act. Stop. It has been brought to the notice of the court that by the learned advocate representing the bank that a SARFACI proceeding is pending consideration before the Debts Recovery Tribunal. Stop. The secured asset has already been sold on public auction and sale certificate issued to the successful bidder.
Lordship.
Stop. The bank is directed to file a report by way of affidavit disclosing all facts and figures relating to the secured asset. Stop. The affidavit shall be prepared and circulated by 14th of November.
Lordship.
Released on 24th of
But
November.
including supportive records, because this is not available.
This means the sale
Notice,
certificate will be given.
Notice.
All right.
Notices and certificate.
No, the e-notice.
Yes.
The public notice.
Public
that
notice
you
and the
bring.
notice served on me.
All right, all right.
All statutory notices.
Affidavit with supporting documents.
Lordship, maintainability of the writ petition may be kept open, Lordship.
All right. The issue of maintainability of the writ petition raised by the bank is kept open to be decided at the time of final hearing. 3.
Item number 3, my lord, I am before your lordship challenging.
I'm for the state, my lord.
My lord, I'm for the respondent number 2 and 3, my lord. I may be allowed to appear virtually, my lord.
Yes.
And for the state, I'm praying not this week. Led
Bye.
by Sonal Sinha, she is out of station.
I cannot help.
My lord, kindly sees I have a point of maintainability. They have challenged the action under SURFACE Act before your lordship.
All right.
Since they have the right under section 17 before the DRT, my lord.
Yes.
If your lordship kindly come to page 83, my lord. This is the sell notice, my lord. Today is the date of auction, 29th. I filed this matter before the vacation bench, my lord. Matter was in the list, but it was not taken.
Right. Tell me how the writ petition is maintainable.
My lord, kindly appreciate, my lord. Loan was about 2 crore 26 lakhs, my lord.
I am not going to the merits. I am not going to the merits. The figures, the court is not concerned.
Go to the tribunal, my lord. I know that I have to go to the tribunal.
Please go.
I have to go to the tribunal. In the meantime, my lord, kindly see, my lord, the date of auction is 29/10, my lord.
Yes.
My lord, in one matter.
Today is
my lord,
29th of October. You obtained leave on 14th of October.
No, my
You
lord.
had enough time.
25/9/2025. This was issued.
All right.
My lord, kindly.
You had enough time to go before the tribunal.
One thing, my lord, they have filed one section 14 application that was rejected.
Yes.
That came before your lordship, that was also rejected, my lord.
Yes.
This is the situation, my
Then?
If your lordship kindly stay this sell notice for a limited period so that I can go before.
So the High Court has become a stopgap arrangement type of thing or what? You come here, obtain a stay, and then you go. What do you mean?
For a limited period.
Why limited? I can give you stay for eternity, provided the court has the jurisdiction to do so. If I do not have the right, how can give it to you even for a day? Please come. The petitioner challenges the act on the part of the respondent numbers 2 and 3 in taking steps to sell the property, sell the secured asset under provisions of the SURFACE Act. Stop. The petitioner has defaulted in payment of the loan amount for which the bank proceeded against the petitioner under the aforesaid act. Stop. Today is the date fixed for sale.
Auction, my
For auction of the secured asset. Stop. Paragraph. Prayer has been made to stay the auction process till the petitioner approaches the debts recovery tribunal for substantive relief. Paragraph. Learned advocate representing the respondent numbers 2 and 3 raises preliminary objection with regard to the maintainability of the writ petition. Stop. It has been submitted that the writ court is not the proper forum to adjudicate the issue. Stop. Next. Upon hearing the parties and on perusal of the documents annexed to the writ petition, it appears that the petitioner has challenged the action of the secured creditor to recover the loan amount in accordance with the provisions of the Act. Stop. Such action is amenable. Now, such action can be challenged by any person before the debts recovery tribunal. Stop. Next. In view of the above, the court is not inclined to exercise jurisdiction in the matter. The writ petition fails and is hereby dismissed. Stop. It is made clear that dismissal of the writ petition will not stand in the way of the petitioner to approach the competent forum for relief in accordance with law, if so advised.
My lord, subject to limitation, my lord.
I have mentioned in accordance with law,
My
I
lord.
have not condoned the limitation period.
And my lord, the respondent number 2 is a NBFC, my lord. It's not a bank, my lord.
Oh,
My lord
আচ্ছা।
has written.
Respondent number 2 is an NBFC, ব্যাংকের জায়গায় financial institution হবে।
Much obliged, ma'am.
Service we kept to the record.
Yes, service is taken on record.
I am for the writ petition.
Lord, I am for the.
My lord, I am filing my affidavit of service. This is a matter, my lord, where the issue has already been decided by your lordship on the previous occasion. In a brief nutshell, may I say the facts of the case? My lord, petitioner is a registered licensee with the railways, and in that capacity has participated in an e-auction tender issued by the railways for installation of 4 scanning machines. Now, my lord, petitioner emerged as a successful bidder. Accordingly, e-auction agreement was executed by the senior divisional commercial manager of Kharagpur division. Now, my lord, thereafter, my lord, I operated the contract for a period of 1 year, and there was an allegation against me that there is a deficiency of service for not installation of 2 further scanning machines. And I replied to them with a plausible explanation that for that reason, I need to have deputed railway personnel officers along with the RPF personnel to at least man the security of all these scanning machines. And my lord, thereafter, my lord, the show cause was issued. I replied.
All right, what is your prayer?
My prayer is this, my lord, I was terminated without giving an opportunity of hearing. And not only that, my lord, the termination has been effected by a very subordinate authority who has not been.
Order of termination?
Order of termination, may page 71, my lord, kindly come.
30 July 2025. Yes, 71.
Just page 71, my lord, kindly see.
Yes.
This is done by the assistant commercial manager. Now, my lord, kindly see the show cause letter which has been issued, that is page 65 of the deed application.
Yes.
This is by the senior divisional commercial manager with whom I have entered an agreement, and the copy of the agreement is at page 37 and 39 also.
All right.
Now, my lord, on this score, my lord, this honorable court on previous occasion, my lord, referring to a division bench judgment and other coordinate bench judgments, came to a categorical finding that the assistant commercial manager do not have the power to terminate my contract. My lord, this is the judgment. This is the order, my lord. I will be relying heavily.
Wait a few.
And very recently, my lord, another coordinate bench judgment has also passed a similar order.
All right.
Similar issues, facts, and here also involved.
My lord, 2 times focus notice.
Please wait. Go through the order that has been passed.
1 point. My lord, 2 times focus notice means that 2 times got the opportunity. Number 1. And writ petition is not maintainable because of that. According to the civil procedure code section 80, my lord, secretary cannot be a party. Earlier occasion I have told that matter. But point is that, my lord, it is very much clear that he got the opportunity, but violation of the contract. My lord, can you look at the page 65?
You please say as to whether the junior officer could have passed this order of termination. Please submit. What is your submission?
My submission is that, my lord, first thing is that opportunity, my lord, I have given.
Don't go to the opportunity. The jurisdiction of the authority which passed the order of termination, is it proper or not? Tell me this. Only one query of the court.
My lord, actual fact is that, my lord.
No fact. Whether the person
no information is there, my lord, authority. That is the difficulties, my lord. I cannot say about this matter.
Right.
My lord, they have initiated a tender tomorrow on 30th on the same self cause, my lord. Let that be stated, my lord.
No, sorry.
Well, either tender is not
sorry,
my lord. In that case, my lord,
that is an absolute separate cause of action.
Well, I have challenged that. I have challenged that. Well, look, kindly see. Page 30, tender is at page 124.
Well, it's not only illegal, my lord, they have not given me an opportunity of hearing. Neither the show cause was accompanied with any documents. No inspection, no inquiry was done. I was not provided any opportunity of hearing, my lord. And they terminated me illegally. And now they are opening another tender to justify their illegal action.
I can understand the 2 times show cause notice. That means,
You have mentioned this 2 times. I have heard this 4 times.
that time he did not comply that.
Right,
that matter
please wait.
It's 124.
Already violation.
124 is the auction catalog.
Yes, tomorrow, my lord, kindly see auction close time date 30th October 2025 at 13:50 hours. That is at 2 p.m.
Yes.
Well, if that is given effect to, I will be thrown out because my right goes. At least till my case is considered, my lord, let them do not give any effect to that. This is my humble prayer before your lordship.
No, only for 2 CCTV installation. According to the contract, 4 CCTV installation to the station. Fact is that
Well, you were given opportunity of hearing twice.
No. I have given a reply. They have given me a show cause. I have given a reply, point-wise reply. That reply was also not taken into account while terminating my contract. But the averment has been taken into account. No opportunity hearing was given. Cyclostyle show cause notice, cyclostyle 48 hours notice. And whatever I have said, I have only said that whatever you are saying that I will be complying it. If not, I have complied within 10 to 15 days. That was, but they have not taken me into confidence. Personally, they could have issued a notice to me for a hearing. I could have explained my facts over there.
No, but then you have explained your facts in your reply to the show cause.
But that was not taken into account, my lord. Kindly see the termination notice. Kindly see the reply to the show cause. Just
all right, please come.
Kindly see 66 page.
Paragraph number 1 টা থাকছে show cause reply to the show cause notice. Show cause notice এটাও থাকছে violation of principle. আচ্ছা, এখানে একটু অ্যাড করুন তো 3-এতে star 3 star. It has been submitted that the reply to the show cause submitted by the petitioner was not at all considered by the authority. তারপর হচ্ছে এই লাইনটা থাকছে contract agreement dated July 7, 2024. Commercial. হ্যাঁ, এটা থাকবে সিনিয়র ডিভিশনাল কমার্শিয়াল ম্যানেজার থাকবে issued by the notice of notification to the assistant commercial manager. এটা থাকছে ও এই পয়েন্ট এখানে লেখাই আছে, আর ওটা দরকার নেই, এটা এখানে লেখাই আছে 4টা বাদ 6 এ লেখা আছে। সবটাই থাকছে, এখানে একটা লাইন অ্যাড আপ করতে হবে যে Page 124 is the auction notice.
Yes, my lord. Page 124 is that auction notice.
All right. একটা প্যারাগ্রাফ একদম শেষে 13 পর 14 নম্বর প্যারাগ্রাফ ডিসপোজালের আগে অ্যাড হবে
Yes.
the respondent authority now it is expected that the respondent authority will not give any effect and or further effect to the auction notice that has been published and annexed at page 124 of the writ petition till a decision is taken by the authority mentioned herein above in accordance with the order passed. Writ petition disposed.
My lord, exercise will be completed within a period of.
Is the time given here? At the earliest. Shall decide the matter afresh. এইখানে 13তে at the earliest. At the earliest.
Grateful, my lord. Grateful.
Yes.
Well, it's a temporary respite which I am praying
my
for.
lord, start, my lord, I have a point of demerit in this application.
My lord, page 52A, my lord, I want my passport back for my travel outside, my lord. My lord, the ministry has permitted me. My lord, the last page of the can, my lord, can 2, 52A. This matter was earlier taken up by your lordship, my lord, where an FIR was registered in Kolkata, which was subsequently quashed by the Honorable High Court at Jharkhand. Now, my lord, there is a SLP filed by the state of West Bengal, though no SLP was filed by the state of Jharkhand, but Honorable Supreme Court has only issued notice, no stay, nothing. Now, the petitioner was granted antecedent bail by this Honorable Court. Sorry, my lord, the bail. Bail was granted by this Honorable Court, initially interim, where the condition was to deposit the passport. That bail was made absolute, my lord. Post thereafter, my lord, the proceeding was quashed. As your lordship is aware of, my lord, if the proceeding gets quashed, so there is no bail, no bail bond, nothing, etc. But since the matter is pending before the Honorable Supreme Court, my lord, your lordship's pleasure was that there will be a status quo for the time being. My lord, we don't want our passport back permanently. Kindly see page 52A, my lord. If the travel itinerary is also in the notification, my lord, in the permission by the government, my lord, from 2nd of November to 9th of November. I'll come back by 9th and I'll deposit my passport again.
What do you do?
My lord, I'm a minister attached to the Ministry of Jharkhand, my lord. My lord, kindly sees, my lord, that my lord, subject regarding granting permission to my lord, the petitioner, Honorable Minister of Department of Health, Medical Education and Family Welfare, Food, Public Distribution and Consumer Affairs Department and Disasters Management Department for foreign travel, World Trade Market 2025 at London, United Kingdom, organized by such and such. And my lord, the date also your lordship will have.
What is the purpose of your travel?
My lord, I was invited by them, my lord. If your lordship's pleasure will be to come to, my lord, the application at paragraph, my lord, 8 at page 4.
No, show me the invitation letter. Who has invited you? Who are these people?
My lord, who are the organizer, my lord?
Recent Medi tour?
My lord, that's the organizer, my lord. At page 50 is the document, my lord.
It's not that if you
51 is not legible, my lord. I can read it 50 and 51.
51?
My lord, it's
51.
No.
51?
50, 51 both.
Oh, both. You cannot read. All right.
Only but that's reflected in the
Assuming you do not go there, you don't lose anything. Neither does the country gain anything if you go there.
Well, kindly appreciate the from
Why you are going there
Well-
for pleasure purpose?
not that, my lord.
Absolutely
My lord,
yes.
kindly appreciate, my lord. I'm a free man. There's no proceeding
Certainly.
against me against my lord.
Certainly, you go before the Supreme Court and obtain orders.
Well,
You are
I
before
don't
this
require with
court.
deepest respect, my lord. The Supreme Court, they have approached and Supreme Court has not granted any stay. So, my lord, what is
Yes.
the situation? My lord, kindly give me 2 minutes. My lord, as on date,
No, you say that no proceeding is pending. Accordingly, they cannot hold back my passport.
absolutely.
This is
Now,
the
my lord,
only thing.
that matter, your lordship wants to decide.
Yes.
But as an interim measure, my lord, I want my passport back only for limited period. But I don't see.
Understand. Listen, had it been for health issues, had it been for any other emergency issues, it would have been all right.
But
You
it's
are
for the
just going
ministry
there
to
for fun.
represent, my lord.
The ministry is.
But is the
Right,
ministry to be
will
represented?
the minister will again get a chance to go abroad. Let
But my
all
kindly
these
appreciate,
cases
my if
be
I, my lord,
and what is your objection? Where is this? Is
there's
this
no proceeding pending against me, nothing, my lord. The bail order evaporates the moment, my lord, proceeding gets terminated.
Yes.
Now, my lord, I have a strong.
What is
I
your
have
objection?
three things, my lord.
Are you apprehending that he's going to flee and not come back?
One. And second, my lord, what my learned friend argues, submitted today before lordship regarding the Supreme Court, they had not uttered any word in the application. And the writ petition, my lord,
In the writ petition also, it's not there.
no, in the writ petition it was there. In the
Oh,
application,
so you are aware of it that the and it is
in
your
lordship's
appeal.
order. I'm sorry.
I have not interrupted you.
No, it's in lordship's order reflected.
1 minute.
I'm
Let
sorry.
me make submission.
Lord,
Yes.
when this writ petition was disposed of your lordship, there was a misinterpretation between the advocate and the officer, my lord. Thereafter, we moved and appealed before this honorable court. And the appeal court was pleased to direct us to file a recalling application. Your lordship was pleased to hear the recalling application itself. While recalling the order of your lordship was pleased to direct us to file an affidavit. Though in a belated state, we are late by some days, but we filed the application. But rather the opposition, they were directed to file the reply. In spite of filing reply, my lord, they have chosen not to reply to the same till date. And they have come up with an application. In this application, my lord, kindly have a look at page 52. This is not a direction, or this is the thing. निर्देश अनुसार उपयुक्त विषय के संबंध कहते हैं कि इरफान अंसारी माननीय मंत्री चिकित्सा सचिव सच विभाग झारखंड सरकार द्वारा दिनांक 7 तक सरकारी व्यय पर विदेश यात्रा लंदन यूके की स्वीकृति संभव subject to statutory clearance. It's not that his presence is mandatory.
Yo, that I said that he's just going there for fun.
Yes.
He on the expenses of
moreover,
who?
my lord, this passport was deposited as per the order of the honorable division bench, but not by your lordship's order.
The division bench has disposed of the matter.
Yes,
And now the proceeding has been terminated, my lord.
And
So as on date, my lord, there is no case against me, despite the state is apprehensive of my absconsion. So it's hilarious, my lord, with deepest respect. And I'm a minister, my lord, cabinet minister attached to a ministry. The government is financing, my lord, and they have their objection to that.
Certainly, if you don't have the FIR against you,
Without going into FIR, I just want to know whether your going over there will benefit the
Definitely, my lord.
country.
My lord, I will
How?
definitely, my lord, I will represent the government, which is why, my lord, I will be financed by the government. You also have seen page 52 and 52A.
Let somebody else go. Please come. The petitioner prays for a direction.
My lord, kindly appreciate, my lord, I am a free man, my lord.
Yes, yes.
So today, my lord, without any case being against me, my lord, I will not be allowed to go. When the ministry has cleared my
To
clearance,
release
my
the
lord,
passport
well, I will go and come back, my
the
lord.
petitioner for a temporary period from 1st November 25 to 15th of November 25 to enable him to attend the World Travel Market, Excel London.
And this is my fundamental right, my lord.
The Excel London from 4th November to 6th November.
second to subject to correction, second to 9.
No, the travel date from 2nd to, because I have to travel, it will take 2 days, which is 4th to, your lordship has rightly dictated.
It is there in your press, sir.
Your lordship is
I'm
right.
reading it from
No,
there.
but he is indicating something. Your lordship is right.
ঠিক আছে the petitioner has annexed the document of the Jharkhand government dated 21st October 2025. Disclosing that the petitioner received the approval from the competent level for his foreign trip at the government expense. Stuff paragraph. It has been it has been submitted that though an FIR has been registered against the petitioner, the FIR was quashed.
FIR was quashed, my lord.
But the same stood quashed by the Honorable Court, Honorable High Court of Jharkhand at Ranchi
Obliged, my lord.
in
My page
WP within bracket CR number 483 of 2022 on 3rd March 2023. Stuff. Next. It has been submitted that an SLP filed by the state of West Bengal is pending consideration before the Honorable Supreme Court. Stuff. Is the number there?
Yes, yes. 7787 of 2023.
Number
May I have the-
Number to লিখে নেবেন, please. What
No,
happened? This is January 24.
They have not come up with an they are what would you do? Affidavit. They are
What
what for filing affidavit by them.
No, this SLP.
Yes, my lord.
It is your SLP by the state,
My lord.
right? All the respondents shall file reply within 4 weeks, list after 4 weeks, and non-miscellaneous day. This is the order of January 24.
Thereafter, they have not come up with the affidavit. They have not filed it.
Maybe they have not come. What steps have you taken to get this matter disposed of? You keep it pending.
But it's pending, Lord. Whatever it is pending.
It is pending, for which the petitioner is languishing.
They can file their affidavit. And here also they have not filed their objection. My lord. They have filed it.
Assuming.
In fact, you are
What is
saying
it?
subject to
Assuming-
objection. Yes, we have filed it.
Wait.
I'm sorry.
Assuming that the petitioner chooses not to file the affidavit. You cannot
then we
force somebody.
then we have to go by that.
So the time has expired long back. Time was given for 4 weeks.
In January.
24.
My lord.
We will be entering January 26 very soon.
My lord.
Then
We have to take steps, my lord. We will. From
We will.
2023.
when you are objecting,
No, Lord. They have not come up. They are kindly see their bona fide also.
the court is not convinced to pass order because the court is not very sure as to whether his going out on government expenses will help the country or not.
My lord.
But then what is your stand to object? I do not know.
My thing is they kindly see.
My lord,
may I take just 30 seconds? But kindly appreciate whether the country will be benefited. That has to be considered by the ministry. Ministry has accorded permission, my lord.
Very well. Let me
Kindly
please
appreciate, my lord. Now, how can that be interfered with or my lord now interjected at this stage, my
go
lord?
before the honorable division bench and get an order.
But there cannot be any appeal against this order. Your lordship is aware of, my lord.
কি বললাম?
Well, the government has permitted me, my lord.
Is
And it's
pending
only for
consideration
7 days.
For the honorable Supreme Court. একটু আগে থেকে বলুন। Yes. তারপর it is pending before the Supreme Court. ঠিক আছে? It has been submitted that the petitioner does not have any reason to abscond, and the petitioner will return immediately after the event is over. Stop. The period for which the petitioner has been permitted to leave the country is also recorded in the letter of the Jharkhand government. Stop. Next. Learned advocate representing the state respondents vociferously opposes the prayer of the petitioner. Stop. It has been submitted that the passport of the petitioner has been deposited in terms of the order passed by the Honorable Division Bench. Stop. The there the state apprehends that the petitioner may abscond. Step paragraph. Upon hearing the parties and on perusal of the documents placed before this court, comma, the court is not satisfied with the reason for the petitioner for his travel abroad on government expenses. Stop. It does not appear that there is any emergent reason for the petitioner for immediate travel. Stop. The writ petition is pending consideration for hearing. Stop. Necessary order will be passed after the writ petition is taken up for final hearing. Stop. The prayer of the petitioner for releasing his passport on temporary basis cannot be allowed.
May I make one statement with your lordship's leave? My lord, kindly appreciate this. My lord, your lordship has passed the judgment, it's enough, my lord. But kindly appreciate, my lord, I'm a free man. Do I need to satisfy anyone that why I will go outside, my lord?
Certainly not.
So then in that case, my lord, and your lordship, in fact, my lord, sat in appeal over the order of the Ministry of Jharkhand, my lord. Obliged.
My lord, in this matter, I am led by Mr. Advocate.
It is your name that will be recorded. Anybody who is not visible will not be there in the order sheet.
That's why I indicated.
I know that.
Obliged.
Yes.
My lord, item number 13, Mr. Jayantanaran Chatterjee is appearing on behalf of the petitioner, my lord. I'm praying for not this week, my lord.
Item number 13, my lord, I am appearing on behalf of the state, my lord. My lord, on the last occasion, my lord has directed to file a report on behalf of the state. But since the state authorities are on a holiday till yesterday, they could not submit any kind of satisfactory conclusion. Since no conclusive instruction has been received, my lord, I am praying for 1 week's time. But verbally, they have communicated that there is no pension scheme and it is for the SALSA or the District Legal Services Authority only to formulate a scheme. But no such scheme has been formulated yet.
See, the order was passed on the 17th of September and today we are on 29th of October. Even today you couldn't prepare the report.
Yes, my lord, but till
Please come.
yesterday...
Learned advocate representing the state respondents seeks extension of time for filing the report in terms of the direction passed by the court on 17th September 2025. Stop. Learned advocate for the petitioner seeks accommodation. Stop. In view of such submission, release the matter for further consideration on 24th of November 2025. Stop. The report shall positively be prepared and circulated prior to the adjourned date.
Great, my lord.
My lord, I'm for the bank, my lord. My lord, this is that matter where the petitioner seeks the release of the baby whilst challenging the services.
Yes.
My lord, I have communicated with the learned advocate and she says she's no more engaged in this matter.
None appears on behalf of the petitioner at the time of call. Stop. The where is the SARFAESI proceeding disclosed?
Well, it's a very vague petition.
I do
Very
not
vague.
see
I could
anything.
not make out anything about while going through it. Because she says that certain policy is there that has to be adjusted with the NP account. All that is not possible. And I mean, it's all irrelevant. And then she seeks in the pair to release her baby. As if the bank manager has abducted the baby. I could not make out anything.
But the police is also a party. The
Yes, then that should have been a police in action. Whatever, she could have gone for that.
Like to bring your notice in. Yeah.
Everything, the grounds, it's very wrongly drafted actually.
On a perusal of the averments made in the writ petition, it appears that the petitioner apprehends that the authorities it appears that the petitioner apprehends that the authorities may hatch out some paragraph 13 hatch out some malicious plan and take action for raising objection to the constructions and running of her business. The petitioner has also expressed apprehension that the respondents may try to pull down or demolish the constructions made by her. On a perusal of the prayer of the writ petition, it appears that prayer has been made to direct the respondents to release the baby of the petitioner. Paragraph. There is nothing on record to suggest that the baby of the petitioner has been taken away by any of the respondent authorities. The facts of the case and the prayer made therein do not match with each other. The writ petition appears to be an utterly misconceived one. The writ petition accordingly fails and is hereby dismissed.
And moreover, my lord,
The instruction
firm also separately in her name.
The communication made by the learned advocate representing the bank to the learned advocate representing the petitioner. No. The communication made by the learned advocate for the petitioner to the learned advocate representing the bank, indicating that she is no longer appearing in the case. Handed over in court today by the learned advocate representing the bank be retained with the records. Next.
I think you appear for the respondent bank, my lord.
Yes.
For yesterday, my lord, they have took time.
Today also there is some resolution.
Every day.
What can be done? I do not know. What is it?
They have challenged the surface action, my lord. They have lodged before the DRT as well as DRT. Their section 17 application, section 18 application has been dismissed by both the forums. Now, my lord, they have
What are you doing now?
They are before lordship for the redemption of their property.
What are you doing now?
My lord, property already sold. We have already sold. Sale certificate issued long back. The matter got NP, the account got
Very well. I'm
NP
just not passing any order. Let it remain in the list.
Friday.
Friday, let us see what resolution comes.
My lord, I am appearing for respondent number 4 board.
I am for the petitioner, your lordship. The petitioner is a company who is which is engaged in the manufacture of plywood and veneer. Now the short question is whether plywood and veneer falls under the definition of agricultural produce, so as to entitle the respondent authorities to impose, collect and levy market fees on such products. There has been a series of petitions filed by various other companies before this honorable court itself, wherein orders have been passed staying directing the respondent authorities from collecting such market fees on the ground that plywood and veneer are not agricultural produce within the definition as envisaged in the West Bengal Agricultural Produce Marketing Regulations Act of 1972. The first order which I would like to place, your lordship, is at page 41. This is the case of Century Plywoods. This is the order judgment of 17th February 2017. Initially, what happened is in 2005, the state actually introduced plywood and veneer within schedule of the act. That was challenged by Century Plyboards. And in that particular case, the coordinate bench of this honorable court, while it kindly comes to page 62, has categorically held that plywood and veneer, which are the manufacturing products, cannot be described as agricultural produce. The reason being, they undergo rigorous process before it is converted into plywood or veneer. Hence, it has been said that plywood and veneer cannot be treated as agricultural produce. This is the first order.
Show me the demand that has been raised.
Yes. We have annexed the receipt. I'll just indicate the receipt.
Receipt means you have paid already?
Yeah, we have already paid on one occasion. We have paid. Now I have also instructions from the client that they are now being prevented, or rather their vehicles are stopped, and they are demanding, or rather imposing this market fees even today. Although I don't have the receipt as of now, but the receipt that was initially, which was given to the client, is at page 77. This is the challan.
What is the position of the appeal?
Any
idea?
My lord, may I say, my lord? My lord, in this matter which has been just placed before your lordship, that Century Plywood, my lord, there the definition clause was not challenged. My lord, what happened is, by way of an amendment, the definition of agricultural produce was extended to include various things which was otherwise not there initially. My lord, that was not brought to the record, that was not even considered. This went up in appeal and it was laying there. Subsequent, my lord, in another case, my lord, there was an issue which was raised with respect to subsequent amendments being affected by invocation of the provision of this act. That has been decided by the coordinate bench, and it has been held that these amendments which has been affected, which was otherwise challenged to be of ultra virus, are not ultra virus, and as such the petitioners were directed to make the payment as was demanded. That went up in appeal, and my lord, I have an order of the appellate court wherein there was a conditional stay upon payment of 50%, my lord, of the amount. My lord, this is what was there. Thereafter, whether that has been paid or not, my lord, I am not really
That is something different.
That's something different.
Right.
But my lord, this is the order I think I should hand up, because this is the updated thing which has happened. Because there, these notifications and these amendments were really challenged. আর একটা copy আছে? না তোকে সাই এটা দিয়ে দেবো।
Yes.
So my lord, the last part, 35, your lordship will find that all these amendments which was held, these were all taken into board, and a compact application challenging the virus of those amendments, which, by relying on that these are basically not coming in the procedure the way it is
This
supposed.
order has been appealed.
This order has been appealed, and my lord, this is the order wherein a conditional stay has been granted. So this is it. Upon payment of 50% of the demanded amount. My lord, this is where it stands today, the current situation. Whereas Century Ply, my lord, is still there the way it is, and it is still pending adjudication before the shipment.
Your Lordship, two more orders.
So
May
what
I
is
only
this?
rely on
This is
two more
the
orders? Your
situation.
Lordship, at page 70, this is in the matter of Greenply Industries. There also this similar point was raised, although this.
Those are of 2022.
Yes, Your
This
Lordship.
order is of 2025. You have to understand.
I have a copy of the order.
I'll hand over to you. I'll ask my advocate on record to give us. You take a snapshot of this, you'll get it in the website only. Both the orders, take it.
Well, this is pertaining to, as far as my understanding goes, Your Lordship, this is pertaining to whether the amendment of 2014 is ultra vires, the Constitution of India. And it has been held that the amendment is not so. Thereafter also, this honorable court, the coordinate benches have passed orders that this particular notification of July 2017, 24 July 2017 will have no effect. And secondly, the regulated committees have been prevented, or rather restrained from collecting and imposing market fees, Your Lordship. Well, this is the order that I'm relying on, is page 75. This is only pertaining to the whether it is ultra vires the constitution, that particular amendment.
My lord is looking into it.
However, my lord, the notification.
But then this has to be decided. At this stage, what can the interim order be?
My lord, the interim order is that the regulated marketing committees should not impose or collect the marketing fees as of date.
Why? You can pay it and the payment shall abide by the result of the writ petition.
This will unsettle the
Because
position in respect of all the other matters where there are interim orders, Your Lordship. That is why I am relying on those orders. My lord, kindly see page 75.
No, what you are
in that case, it is to be heard. Please come.
Your Lordship, I am only
The issue to be
that
decided in the instant writ petition is whether the petitioner would be entitled to pay fees under the West Bengal Agricultural Produce Marketing within bracket regulation bracket close act, 1972. Stuff. The
Your Lordship, only
according to the petitioner, petitioners, the produce, plywood and veneer could not be subjected for payment of levy or market fee under the aforesaid act. Stuff. Reliance has been placed on orders passed by the court from time to time, some of which are annexed to the writ petition. Stuff. Paragraph. Prayer has been made to direct the respondents not to charge any levy, not to impose any levy or market fee on the produce of plywood and veneer. Stuff. Learned advocate representing the respondent number 4, the West Bengal State Agricultural Marketing Board, opposes the prayer of the petitioner. Stuff. Reliance has been placed on the judgment delivered by a coordinate bench of this court on 6th May 2025 in WP numbers checkup, wherein the court was of the opinion that the challenge to the vires of the West Bengal Agricultural Produce within bracket regulation within bracket Amendment Act 2014 and 2017, and also the notification numbers. Page 35 একটু copy করে নেবেন তো, are inter vires the constitution. Stop. Next. The order of the Honorable Division Bench
my lord, only one thing, my lord, this particular
passed by the court on 20th August 2025 in FA numbers এত and এত,
my lord, this pertains to rise back,
challenging the
doesn't matter.
order passed by the Honorable Single Judge has also been placed before the court, wherein the court was pleased to direct the appellants to deposit the assessed outstanding market fees and the same would and the payment shall abide by the result of the appeal. Stuff. Next. the in line with the direction passed by the Honorable Division Bench, comma, the petitioner is directed to pay the charges levied by the authority. Stop. The payment so made shall abide by the result of the writ petition. Stop. Let affidavit in opposition be prepared and circulated within a period of 4 weeks. Reply, if any, within a fortnight thereafter. Liberty to mention upon notice on completion of the aforesaid time period.
Lordship, I'm actually praying, my lord, the market fees be not imposed at this stage, your lordship. My lord, your lordship, kindly considers, my lord, the market fees be not imposed at this stage, your lordship. I am seeking a protection only to that effect, your lordship. If we are made to pay, my lord, there are other orders of the court, your lordship. Kindly consider.
যেখানে বললাম না will pay if imposed. ঠিক last একদম if imposed.
Much obliged.
Yes.
My lord, I am appearing on behalf of state, my lord.
Yes.
Last occasion, they have supplied certain information, Lordship. There needs some clarification.
But in the right to information application, we had sought for details with regard to 15th pay commission, 15 finance commission, the money which has come to the panchayat. We had sought for certain informations. They have provided a bunch of documents. Now, my lord, I have found out many things from that bunch of documents. Now, what I am praying before a lordship, let them either certify that these are the documents which they have given under the Right to Information Act, or they should put the same thing in one-page affidavit before lordship, so that subsequently they cannot say that no, I have not given this document. This is my only prayer before a lordship today.
State.
My lord, I am for the state.
My lord.
Thing in an affidavit.
All right, I got it. Who forwarded these documents?
These documents
the
have been
state?
forwarded by the block development officer.
Video?
Rampurhat, Birbhum.
All right.
My lord, may I allow to make a submission before your lordship?
Yes, please.
As per the RTI Act, if the petitioner is aggrieved by the RTI officer, he has to file the appeal before the appellate authority. But he did not approach to the appellate authority, and he approached to the writ court, my lord.
Listen, that is not the challenge here. Certain documents have already been forwarded. Let someone take the responsibility to say that these documents have been submitted under the provisions of the RTI Act. Nothing more than that.
My lord, I agree, and I will abide by the direction of my lordship, my lord.
Please come.
It has been provided as per lordship direction.
Yes, right, true. But under the RTI Act, because the petitioner has a right to challenge the same before the competent forum.
Let this come
One-page document that these documents are provided under the Right to Information
Act.
Act
Come on record. That is
will be over. Acha. A very voluminous, is it paginated?
No, it is not paginated.
How many pages are there?
750
750 pages?
Bills by which the panchayat has spent money.
No, it doesn't matter. With this,
chicken, mutton.
whether spend, not spend is different. The
Okay,
court is
okay,
not
that
is it
will-
700 pages?
Yes.
More than 700?
More than 700.
Ask for those documents, my lord.
Whatever.
Nothing has been.
A bunch of documents consisting of more than 700 pages have been handed over to the learned advocate for the petitioner by the learned advocate representing the state respondents. After collection of the documents, not collection, after forwarding of the documents by the block development officer, Rampurhat 1 development block. Stop. The concerned block development officer is directed to prepare an affidavit stating that these documents have been supplied under the provisions of the Right to Information Act. Stop. Let such affidavit be prepared and circulated by 14th November, released on 18th of November.
My lord, only these documents may be annexed. This should be brought on record. Mere one-page affidavit saying that these documents have been, because there will be no particulars, because there is no stamp over here.
All right, all right. All right.
Let them kindly.
As it is, the court has not kept those documents because they are so voluminous.
But I had handed over.
That is why.
The learned advocate sought to hand it over. I didn't.
Yes, I remember.
Just annex the affidavit.
That is why I'm saying. That is why I say, my lord, if I proceed on the basis of this document, they may come subsequently.
Photocopy, you intended to hand it over to the court.
Yes.
Prepare an affidavit, annex it with this, and hand it over.
Yes.
It's as simple.
Annexing these documents. Then we'll have a, my lord, appropriate thing to proceed subsequently.
29.
18 November. 18 November. I have informed.
Who is appearing?
Yes, yes.
Are you there for the private respondent?
State also. I have also informed. My lord, Mr. saying, I thought the state response is out of station. My lord, kindly not to different.
How long will he remain out?
Friday is Friday.
Friday is going to come.
He's told me he's coming.
He's coming.
What?
Must be there outside in some other court.
Just half an hour ago, I have
said he's coming. I'll pass it over.
No, that I don't know. But yes, I shall be patient.
Yes.
The matter was dismissed for default, and that was the instruction which was given even on the case status that was showing dismissed for default. So we had returned the brief. I wasn't told of the advocate record. I was informed yesterday that the matter is being listed before your lordship. I've taken the brief back. Kindly make it not today. Please be ready by tomorrow.
All right, not today. Friday.
Then tomorrow. Then lordship Tuesday, lordship tomorrow.
Tuesday. Tomorrow is a holiday. Friday.
Friday I may not come.
Acha, on the prayer of the learned advocate representing the private respondents and the state respondents, hearing of the matter stands adjourned till 4th of November. Tuesday.
Madam, applying for the
My lord,
PA possibilities, madam.
this is my application, my lord. On 17th, your lordship was pleased to pass an order.
What has happened to your voice?
Because of change of climate.
All right. Yes.
And there is an order, my lordship, kindly have a look to your lordship's order. This is an application, my lord, a direction upon the employees Provident.
Yes, I'll read it. What is there? To delink his Aadhaar card with the records of his uncle since deceased, who was an employee. And the petitioner himself declared his Aadhaar and recorded the same. Now the employee has expired. The petitioner is there.
Yes.
What is the problem that he is facing?
Paragraph 6 is, my lord, because, my lord, they didn't delink the Aadhaar number from their KYC of a deceased uncle. Lord, this employer of this petitioner, they are not giving salary to petitioner because of non-production of Aadhaar, and the Aadhaar was relinked in the KYC of a deceased uncle. So your lordship was pleased to direct the employees.
Let me hear if something.
I am applying for the PA possibility, my lord.
Yes.
In this matter, my lord, the petitioner himself tag his Aadhaar with the
That you mentioned and I have recorded.
Come with a solution, my lord.
Yes, solution.
My lord.
The
The
Already delinked?
yes, ma'am, already.
Oh, very well.
Madam.
It has already been delinked.
My instruction, my lord.
Your client is not contacting you.
No, no. Milord.
The usual practice. Please come. Yes.
Grameen Bank, my lord.
From the information forwarded by the Assistant Provident Fund Commissioner within bracket legal, regional office at Behrampur, dated 28th October 2025, it appears that the Aadhaar number of the petitioner has been delinked. এটাকে copy করবেন তো। The Aadhaar number of the petitioner being such and such has been delinked from the UAN number এত। ঠিক আছে? Presently, the petitioner can generate new caps UAN through Umang app and provide the same to the employer. Stop paragraph. It will be open for the petitioner to create শুরু করুন as the Aadhaar number of the petitioner has already been delinked. It will be open for the petitioner to generate new UAN number as mentioned by the Assistant Provident Fund Commissioner. Stop. The writ petition stands disposed of. Grateful. Thank you, sir. Grateful. Yes. না থাকলে not today পেছনে রেকর্ড করে নেবেন NT and এটা this will go back in
Asif, I'm saying not today.
all right. You pray RBI. All right, nobody is there, not today.
Number 404, 405, 406, 407, 408, 409, 410, 411.
আর দিকে কাজ নেই দেখো লোক ডাকুন
And I am for the
13, but I appear for the private response.
Yes.
14.
13.
14.
But 14 I am for the petitioner, my lord.
Yes.
14 I appear for the private response.
What is the matter?
The petitioner before lordship is a senior citizen. He has been ousted from her own residence by her own son and daughter-in-law. And my lord, this is the second round of litigation before this honorable court, and also an application was made under section 5 before the appropriate authority under the Maintenance of Senior Citizen and Parents Act. My lord, your lordship kindly turn to my lord page 22, your lordship's brief. Annexure P3, page 27, my lord, I'm sorry, page 27.
Yes.
Well, this honorable court directed the concerned police station to reinstate me at my premises.
Yes.
But accordingly, police took me at my place. And after a few days, because after the ousting me from my residence and my wife, my son and daughter-in-law took entire premises at their own clutches. And when we went there pursuant to the direction of this honorable court with the assistance of the police, they only provided one room. Despite they have not provided the other amenities and all these things, and ultimately assaulted us. And again we were ousted. Thereafter, an application was pending at that relevant point of time before the authority under the Maintenance of Parents and Senior Citizen Act. But thereafter, again a writ application was moved after initiation of the criminal case against the opposite parties. But there also this honorable court passed an order. When the police took me to our residence, only one room was provided, though the premises belongs to us.
No, but then you gifted certain portion of the premises.
Madam?
You gifted certain portion of the premises.
No. Nothing. I gifted one shop room under compulsion. I never gifted the portion, anything of the sort.
And the shop room is outside the.
Outside.
It is not within this premises.
No. Madam, during COVID, they were residing elsewhere after marriage. During COVID, the love and affection we brought to our premises. And these caused all hazards. And ultimately we are ousted. And Madam, your lordship will find the application which were filed before the appropriate authority, page 37, annexure P7. There we have initiated the appropriate proceedings, the relief under the Senior Citizenship Act. That proceedings was dropped since the honorable court passed an order for reinstatement. But page 40, your lordship will find.
Yes,
and
I've seen.
then, my lord, again we have come up before this honorable court. And this honorable court, during pendency of this, we again came up before this honorable court, and this honorable court passed this direction. And also, my lord, we have initiated again a fresh proceedings pursuant to the direction of this honorable court by lodging, filing another application under section 5 before the subdivisional officer.
Joining with this issue.
1 minute, let him finish.
And my lord, previously, the last occasion, sorry.
Yes.
But with this order, we again went to the police station. Police station took us over there. Only one room was opened for us, and no one of the other amenities were provided to us.
The house in question is recorded in the name of the senior citizen.
My wife.
She is also a senior citizen?
Yes.
In the name of the senior citizen, right? Now the sons and the son and the daughter-in-law of the senior citizen is disturbing her in enjoying the house. This is your case.
Yes.
Right?
My lord.
Yes. What does your son do?
My son is doing the business, my lord. My daughter-in-law is is a powerful because she is a lawyer and associated with a particular political party. Therefore, she has enough power, and she is making regular drama and initiating cases at his
All right, I get it. Yes, please.
Kindly comes to the order of my Lord Justice Tikram.
Yes, I've seen that.
But if your lordship sees that order, my lordship, in that order had directed the inspector in charge to provide necessary assistance, and his lordship, my lord, for 30 days, but every alternative day a lady police personnel was engaged, my lord, who would visit and inquire. Now, my lord, there is no report on the part of the police authorities that due to the torture of the daughter-in-law, my lord, the mother-in-law was compelled to leave the premises or the, my lord, the petition. And what they did was, my lord, pursuant to this order, we allowed them, my lord, to enter into the premises.
You allowed? What do you mean to say?
No, my lord, they entered into the premises. Well, it's my.
How dare you say that? It is the property of the senior citizen, and you say that you allowed her to enter?
Entered into their own premises. My lord, thereafter, voluntarily, after 2 days, they left. My lord, there is no report by the police authorities that due to any action, they could not enter into their own premises.
When will you move out of the house?
No, my lord, kindly considers.
Why will you not move out of the house?
No, my lord, kindly considers.
You are representing the respondent numbers 5 and 6, the son and the daughter-in-law.
My lord, kindly sees what the subdivisional magistrate in the earlier order has done. The SDM has dismissed their petition.
I have seen that.
There was a liberty granted by my lord Justice Ghosh to my lord approach.
Tell me one thing, do you own the property?
No, my lord, we have a.
Do you own the property?
No, my lord, we do not own it.
You do not own. It's your parents' property.
Lordship.
You are staying over there. Your parents are absolutely unhappy with your staying over there.
No, my lord,
why will you not move out?
No, my lord, kindly consider.
If you are going on disturbing and torturing your parents?
Of this petitioner, my lord, he is, my lord, not a normal person because my lord, he has.
Now abnormality grows in.
It's long there. It's long there. It's long there. Now, my lord, only thing is, my lord, they have already.
The daughter-in-law is good enough to take care of her husband?
No, my lord, the daughter-in-law, my lord, she is a lawyer, but what my learned friend is.
No, I am not. I am ignoring that. I am ignoring that. Even then, if the daughter-in-law can take care of her husband, please tell her to move out along with her husband.
They have approached the subdivisional magistrate. That is falling with the subdivisional magistrate decide on this issue.
You want the senior citizen to go back to another forum?
There is,
you are a legal practitioner and you will go on carrying her from one forum to the other.
This is not the case. What my learned, let him show a scrap of a document to show that the police has submitted any adverse report that pursuant to the order.
Police? The daughter-in-law is there and the police is going to file a report against an advocate.
That is not.
And the court is here to believe it.
That would have been the situation. Then the order of my Lord Justice Tirthankar Ghosh would not have been passed.
Even if the order is there, the petitioners are feeling inconvenienced and insecure of your presence. Find out a place and when will you go out? No kindness can be shown to children who do not pay respect or torture their parents.
Absolutely,
no.
This is at the instance, at the behest of the other son. There is a younger brother, which my learned friend is not saying.
Now the younger brother story is coming in.
It is there.
Yes.
You cannot dispute that he has two sons. I am the elder son, they
Very
are the
well.
younger son. The youngest, at the younger son's PS my lord, everything is happening.
Yes.
They have 3-4 residences, my lord. They have a residence in Uttarpada. They have my lord, we are not concerned about it. The only thing is, my lord, kindly considers they have approached the subdivisional magistrate.
You were staying out. This is what the petitioner says. You were staying out prior to COVID. Now you've come in.
No, my lord, this is not true. I'm all along staying in that premises.
You are all along staying in that premises. All right. Now find out a different premises for yourself.
Let me take instructions and come back. Lordship keeps it on Monday.
All
I
right.
shall take instructions.
Please come. The petitioner claims to be a senior citizen. Stop. Allegation is that the respondent number 5, being his son, and the respondent number 6, being his daughter-in-law, are torturing the petitioner to such an extent that the petitioner is apprehensive in staying at his own premises along with his wife, who is also a senior citizen. Stop. The petitioner and his wife fears for their life. Stop. Next. The parties have placed before this court the order dated 2nd September 2025, passed by a coordinate bench of this court in WPA number, please copy, cause title also copy, wherein the court was pleased to direct the petitioner, that is the wife of the present petitioner, to approach the tribunal afresh within a period of 30 days. Stop. The court also directed that for a period of 30 days, comma, every alternate day, comma, a lady police personnel be engaged who would visit and inquire as to whether the senior citizens are facing any inconvenience at the hand of the private respondents herein. Stop. The learned advocate for the petitioner submits that despite passing the aforesaid order, comma, the situation has not changed, and the petitioner and his wife feel extremely insecure to stay and reside at the said premises. Stop. Next. How big is the house? How big is the house?
Two-storied, but in second floor, one room. And my lord, there are 3 rooms. Four rooms. In first floor, 2 rooms.
Where is your younger son staying?
But young. But in the first floor, 1 room he is occupying.
The younger son. Yes. What does he do?
In the private company he works.
And he is married?
No.
No. Not married. Are you trying to throw away your elder son from there to only to make room for the younger son?
No, my lord, not that. This is not. The conduct, your lordship, after
this order.
After this order, we went there, and this is.
How many complaints did you lodge before the police?
This is the situation.
But
love and affection divided into 2. But the conduct, how they are, your lordship, I am not placing these things, if son and with the instigation of wife beats her mother, then the situation different. They are not allowing me.
how many rooms is the this
Leaving
son
that,
and the
leaving
daughter-in-law?
that, all they have occupied.
Well, at one room we
They have occupied entire thing.
No.
Then, my lord, when pursuant to the direction of this honorable court, we went there, only one room was allowed to enter. And my lord, we are not allowed to use kitchen. We are not allowed to use toilet. Previously, when we were there, and my lord, pursuant to the earlier order, kitchen was allowed to us. And my lord, when we are cooking in the kitchen, mother was assaulted. The petitioner of this petition was assaulted like this. And then again they left and started residing the sister of this lady's house. They are saying that 4 house, 5
Yes,
house.
we can
They are
produce the deeds.
residing at the relative of the others. And my lord, this time when they came back, only one room was allowed to us. And my lord, we are enter into that, but we are not allowed to cook or use the toilet or anything.
Did you intimate this to the police?
Yes, this is the FIR they have.
No, FIR is different.
Police recorded after that. This is after the
Court's
order.
order. Yes. But then the fact that you are not being permitted to use the kitchen and the washroom, is this within the knowledge?
Not categorically mentioned, but your lordship kindly sees that first floor was the lock was there, that has removed the lock. Your lordship, this is everything has been not narrated, but they were not allowed.
All right. See, the perpetrators are your son and your daughter-in-law.
Yes.
They cannot. You just cannot throw them away.
No,
right?
I am not willing to throw them away.
Yes. Where do you intend to place them in your house? Which room?
But if they conduct like this,
Yes.
then it is difficult.
Right.
But otherwise, they were allowed. They from
Where will you permit them to stay for the time
in the
being?
first floor, I will provide one room. Other boy is providing one room, but in the ground floor, they will not disturb us.
We occupy one room.
আচ্ছা কি বললাম শেষটা?
Despite passing the appropriate order, the situation
Has not been. ঠিক আছে. It has been submitted that the private respondents are not allowing the petitioner and his wife to use the kitchen and the washroom. Next, the learned advocate representing the private respondents denies the allegation of the petitioner. Stop. It has been submitted that the entire picture has been placed before the court at the instigation of the younger son of the petitioner. Stop. Paragraph. On a query from the court, it has been submitted by the learned advocate for the petitioner that there are 4 rooms in the subject house, semicolon, 2 in the first floor and 2 in the ground floor. Stop. It has been brought to the notice of the court that the younger son of the petitioner is occupying 1 room in the first floor. Stop. Paragraph. For the time being, the private respondents are directed to use only the other room in the first floor of the subject house. The private respondents are restrained from interfering with any of the daily activities of the petitioner and his wife. Stop. The direction passed by the court on 2nd September 2025 is reimposed to the extent mentioned herein below. Stop. Every alternate day, for a period of 30 days, A lady police personnel shall visit and inquire as to whether the petitioner and his wife is facing any inconvenience at the hands of the private respondents. Stop. If the conduct of the private respondents is such that the father feels insecure to stay in the subject house with the private respondents, comma, then the court would be constrained to pass order directing the private respondents to leave and vacate the house, keeping in mind the safety and security of the senior citizens. Stop. The subject house in question, now the subject house being owned by the petitioner's wife, comma, the senior citizen has every right to reside at the said house peacefully without any threat of life at the hands of their son and daughter-in-law. Stop. To review the situation, comma, hearing of the writ petition stands adjourned till 8th December 2025. Stop. In the event the petitioner faces any threat at the hands of the private respondents, comma, the petitioner shall immediately report the same to the police station for taking necessary action. Stop. Liberty to mention.
My lord, may I plead for a very short affidavit within this time, 8th of December, but I want to place certain facts before you.
What fact?
My lord, there are certain.
You have a brother, the brother is doing this and all other things.
One thing, may I submit,
I get one complaint that the petitioner lodges before the police. You will be out. Next. Next.
Lordship is they will go to the police station and file another false.
One thing, may I submit, there are certain.
They are your parents.
True.
Keep this in mind.
Absolutely at the instigation of the young.
Yes,
there are
very well.
furniture and other things in the first floor. We
Yes.
have to remove that from that place because.
Where will they stay? On the floor?
No.
What type of furniture is there?
Furniture, there are almara and all these things.
You want everything?
If they occupy, then I have no objection.
Then why are you making this submission? Yes.
116. 118. 119. 120. 121. 122. 123. 124. 125. 126.
Lordship, in item number 421, Lordship, I am appearing for the state, Lordship.
All right.
427, I am for the petition.
What is the matter?
My lord, I have a fertilizer shop, my lord, and I have a license of 2016, my lord. Thereafter, my lord, for 5 years. Then, thereafter, in 2021, I filed an application for renewal of this, my lord, the license, my lord. My lord, this was pending long. Then, my lord, I filed a petition before this honorable court in 2024. Then, my lord, after filing this petition, they have rejected renewal of my application. Against that, my lord, I have come. My lord, they have, well, kindly see, my lord.
Who is the other side?
I have served, my lord.
Give the service.
Yes.
I have.
6th of June 24 is the
Yes, order, my lord.
impugned order.
Yes, ma'am. Kindly see, my lord. As per the rule, every app, my lord, may I read?
What is the criminal case that is pending against you?
My lord, one criminal case is pending. My lord, I have got bail. My lord, I have also filed an application for quashing of this proceeding. But my lord, kindly see, my lord, before that, my lord, applied late. But my lord, there is a provision. If it is late, my lord, I can, my lord, that renewal can be done after.
Yes, but it appears that you were asked to submit some documents which you did not do.
My lord, I have, my lord, I have given.
After, what are the documents that you submitted?
But I have submitted all these documents, my lord. I have.
Please come.
Kindly come from.
Please come.
To
The order dated 6th June 2024, rejecting the 2024 passed by the District Magistrate Birbhum, rejecting the prayer of the petitioner for renewal
Yes.
of the license to possess and sale
of
ammonium nitrate and transport ammonium nitrate is impugned in the instant writ petition. Stop. The license of the petitioner was valid up to 31st March 2021. Stop. Application for renewal of the same was
filed on
26th March 2021. Stop. On a perusal of the impugned order, it appears that the petitioner failed to submit certain documents to prove his claim. Stop. The documents which were not submitted by the petitioner or are wanting for the purpose of renewal of the license of the petitioner is not reflected in the impugned order. Stop. None represents the state respondents. Stop. Let a notice be served upon the learned advocate representing the state respondents. Stop. A report be filed by the District Magistrate Birbhum disclosing the documents required by the petitioner for renewing the license, for renewing his license. Stop. Let a copy of the report be circulated by 20th November, Puri, released on 2nd of December. Affidavit of service filed in court is taken on record.
will come on 2nd December.
Yes.
Yes.
428. 129.
Yes.
Against the order of the Chief Information Commission, Lordship, my lord, what happened? Unauthorized construction in the city of Chandannagar. Number of unauthorized construction, I pray for certain demolition sketch, précis, and other document. My lord, it was denied at the outset. Thereafter, my lord, I preferred one writ application before this honorable court, page 37. My lord, the page 37 says, 4th paragraph, in such circumstances, petitioner is at liberty to either press the complaint filed by the petitioner before the commissioner, Chandannagar Municipal Corporation, as the appeal to file fresh appeal before the commissioner of Chandannagar. Then, my lord, in either of the two events, petitioner will inform the commissioner Chandannagar within 7 days upon receipt of such commissioner. The commissioner Chandannagar Municipal Corporation will dispose of the appeal within a period of 4 weeks from the date of receipt of all this. Then, my lord, page 39, kindly see, my lord, the disposal of my first appeal. What is the fashion of disposing the first appeal by the Chandannagar Municipal Corporation? My lord, they have indicated this is pursuant to the direction issued by the Honorable Court. And then, my lord, third paragraph, reference third paragraph, letter from SPIO CMC, my lord, the 8H, A to H number of references there. With reference to the above, the undersigned has issued letter dated 3/7/2029 to the owner of the said holding number as per provision of the section 11(1) of the RTI Act 2005. Lordship knows 11(1) is the third party information. In the event SPIO intend to disclose certain information at the outside within 6 days or 5 days, they are to inform the particular person.
Anyway, then you are aggrieved.
I am
You
aggrieved.
preferred.
This is the way, my lord, of disposing of appeal. Page 40 may kindly be looked into. Once again, my lord, they are reiterated that they have disposed of the first appeal. No, my lord, sending it before a third party under section 11(1).
No, thereafter, what did you do?
Up to this is up, culminated to the, my lord, the commission. And what is the order of the commission? Kindly see, my lord.
Yes.
My lord, this is very important. My lord, nowadays, Lordship knows it emanates from Article 19. My lord, it's a fundamental right. And now, my lord, kindly come to page 60, paragraph 3. Sri Amit Kumar Ghosh submitted a reply via the mail number so and so. The main points along with the comments of the commission are following. Before this, my lord, order, the commission issued a so-called notice as to why they are not terming me as a the habitual RTI applicant. Whether the four corner of the particular act there is any such provision, I can apply innumerable application. I have the right. My lord, no, I know, my lord, the public authority has to discharge several duties. I am asking for certain information which should be readily available in under section 4, proactive, my lord, disclosure. They are not disclosing all these things. They are passing the buck to some other person. Here, my lord, kindly see, Roman 1, the notice of WBIC for closing all pending second appeal. My lord, they have closed all pending second appeal on the ground of applicant is a habitual RTI applicant. My lord, this particular word must be in the act. My lord, otherwise statutory authority cannot do anything unless permitted by the law. Common man can do unless prohibited by the law. Then, my lord, is it an attempt to stifle fundamental right of the appellant? Terming me as a defaulter, terming me as a habitual RTI applicant. Then, my lord, he filed RTI application as his legitimate exercise of his right. The RTI Act does not provide for any definition of habitual RTI applicant.
These are your submissions.
Yes. That submission, my lord, they have, my lord, termed this submission intemperate word, provocative, impolite, and all these things. And finally come to a conclusion that these particular, all these appeal are closed and warned me, warning in this fashion, page 64 at the bottom. It is therefore ordered that all 11 second appeal complaints submitted by the Amit Kumar Ghosh to the WBIC pending for disposal are closed without any further action. Besides, Sri Ghosh is cautioned to be careful about the intemperate language used for the commission in his written communication on oral submission. This has reference to paragraph 5. I am reading, my lord, what was my submission. Sri Ghosh is also advised to use right to information under RTI Act in future as per the aims and objective of the Act and the direction of the Honorable Supreme Court of the Honorable High Court. Nowhere such direction has been issued by the Honorable Supreme Court. My lord, they have referred one judgment of Aditya Bandyopadhyay versus CBSC. Lordship knows. There, my lord, the evaluated answer script is required to be produced to the candidate.
That is something different.
There, my lord, in a particular paragraph, occasional remarks are there. The public authority are discharging their duties and function. If they are flooded with number of application, my lord, what they will do? System to be developed, separate SPIO to be, my lord, appointed and all these things, since this act is, my lord. Now, my lord, kindly see what is my intemperate language. What is there, my lord? My reply against the shokaj. My lord, this is required to be heard, my lord. I think, my lord, exchange of affidavit and commission should come forward to share as to how and why they are trying to snatch my right. Lordship, kindly come to page 58. They have referred 2-3 paragraph. I'm reading, my lord, this 2-3 paragraph of my shokaj reply.
Prior to that, show me what are the informations that you see.
Very innocuous information. I'm coming, my lord. That is very innocuous information. I am asking for from the municipality, page 43. Whether it comes within section 8, is it possible, my lord?
What do you do?
My lord, my lord, page 6, page 43, 6. Sketches and plot map of the premises. Copy of the original sanctioned building plan. And, my lord, file noting while obtaining original sanctioned building plan. Copy of the file noting of the post regularization done to the building of the said premises. Lordship knows even.
Oh, what do you do?
Myself. But I am a resident of Chandanagar.
You are a resident
yes,
of Chandanagar.
The thing is this.
You work somewhere? Attached? Do you work somewhere? Are you attached to any political party?
No,
You are.
Even then, my lord, the act protected.
No, that is
No,
something
no,
else.
no, my lord, no, my lord. No, my lord, I
Nothing.
have some association with the civil right organization. That is a
You
different
have.
question altogether. Yes, my lord.
All
Different question altogether. And act protected me as to why I am asking a question before the RTI authority. I should not disclose.
What do you do? Tell me, what do you do?
My lord, myself doing some business.
What
I am
type of
associated with a
business?
civil right organization, namely APDR, Association for Protection of Democratic Right. Though, my lord, I did not disclose all this. Act has protected me. I can
No,
show
it's
from
all right. What type of business do you do?
My lord, my business.
Yes.
My business, my lord, I am to take that particular instruction. I am not an employee, I know, but I have obtained 60 years age also. That is a different question, my lord. Different question. I will take that instruction on the, if this honorable court direct them to file.
How many other RTI applications have you made
different
before?
premises are there. Different premises. Yes, my lord, 21.
21.
If there are 21 unauthorized building, if I intend to, my lord, get the information and come to before the honorable court in public interest litigation, my lord, otherwise court will say,
Who is funding you?
my lord, funding.
Who is funding you?
For RTI Act, lordship, no.
No, not for the RTI, for approaching the High Court.
Approaching the High Court.
Who is
my lord,
funding you?
always fund is not pro bono works are also there, my lord. Kindly remind that.
Pro bono work for the lawyers.
Lawyers.
But what about the filing, the service, and there is some
minimum
charges?
My lord, I am submitting in this fashion. Lordship is putting some question which, my lord, this particular act, my lord, the prohibited. I am showing my lord, the act itself.
Do not show the act. This is the
So, lord,
query in the mind.
I'm
Query in the mind of the court is. I wish there were many people like you, so that the unauthorized construction would not have been there.
They approached us, requested us. We also think, my lord, RTI Act emanates from Article 19. This is kind of fundamental right. And, my lord, the gagging by the commission is not permissible. Not only this case, if lordship direct me, I can show number of cases where, my lord, commission nowadays passing this type of order. Whether the, my lord, the commission can pass that order, that is required to be decided by this honorable court.
That will be decided.
And, my lord, direct me to disclose. I will disclose all my profession and all this thing. If I have a businessman, I will show, my lord, the certificate of enlistment and other thing. My lord, I think.
And you have a house where you stay.
Lordship.
That is constructed in accordance with the sanction plan.
Yes, my lord. That is a different story altogether. Even then, my lord.
There is a story.
Yes, my lord. Story. Lordship possibly recollect. Lordship recollects it in appropriately, my lord. The thing is there, my lord. I am not disclosing, but I will disclose at the time of filing reply in the event it is required. Supposing, my lord, mine have a minor infraction.
Yes.
And a person in the municipality are sitting there, allowing multi-storied building to be erected without entering into that.
Right.
This minor infraction is required to be regularized by the provision of the Municipal Affairs Department. And municipality is considering that aspect also. Since, my lord, I have approached with this gentleman before, my lord, court group 5 jurisdiction. It is still in the memory of this honorable court. My lord, I appreciate the memory of this honorable court. But no doubt in it. But at the same time, kindly allow me to show the provision of the law, section 7. But whether I require to disclose as to why I am asking this information, the act says no. So I'm 6.2. My lord, I am coming. But just, my lord, for academic discussion, lordship rightly raised this question. An applicant making request for information shall not be required to give any reason for requesting the information or any other personal detail except those that may be necessary for contacting him.
Yes.
Lord, first and foremost, Lord, I am reiterating my submissions that being a quasi-judicial authority, Lord, I am not supposed to, Lord, defend my own orders tooth and nail. And that is not my instruction also. Lord, if your lordships kindly see the paragraph 1, there were 21 second appeals from the applicant. We have dealt
where
with 10
is
second
where
appeal
is
one
the
by one.
Chandanagar Municipal Corporation today?
My lord, we have effected service upon them, my lord.
You have effected service?
Once again, I can, my lord.
Yes, please do. Because the information is required to come from the corporation.
Municipality. And this is not within the section 4.8.
It is not
and
the
we have
commission's.
objection also, Lord, if you
Yes, my lord, see.
give directions to
That
provide
I
the-
understand.
Lord, we have identified, Lord, 10 to 12 persons are there those who are filing huge number of RTA applications for their own benefit, that we do not know. But for that reason, there is one applicant, that is Biplab Chaudhary. He has filed more than 150 second appeals before the commission.
So
Those who are original bona fide applicant, they are, my lord, sitting behind the 200, 300, 500 applications behind. And we are taking up the matters chronologically. Apart from those, the High Court give directions to expedite the matters.
Statutory authority,
So for
whether
that
can do.
reason, my lord, we have for 10 to 12 applicants are there. We have taken these type of views that they are filing one after another RTA applications, second appeals. So we have closed.
Have you checked up whether the informations are sought
Yes.
for other illegal gains or not?
No, we have not checked. We have not checked. For that reason, my lord, if your lordship say no, you are supposed to deal with each and every second appeals, we will do that. But if we do not do for some applicants, my lord, the original bona fide applicants, those who have filed only one application, one second appeal for his retail benefit, for his examinations paper, he will not get the opportunity even, my lord. Since, my lord, statutes.
Please come.
My lord, only one submission, my lord. My lord, there are 10 commissioners, there must be 1 or 2 commissioners are functioning. This is failure of the state machinery. One applicant, his name was Jolodhar Pulle. My lord, at a point of time, he filed one application, number of applications. Justice Dotto entertained this application, directed Chief Secretary, it will be viewed seriously unless or the commissioner are not being appointed. So, my lord, that order, after that
There
order,
are 72 vacancies in this High
10.
Court. We are functioning with only 47.
True, my lord. That
What is to be done?
That is one aspect.
No,
Outside
then
the
it is the same thing.
outside the court,
Same thing,
we
yes.
used to talk that is required to be filled up.
It's required
And load
to
is
be filled
required
up.
to be reduced in that
Right.
case, my lord.
Yes, true.
We are in the each and every morning disturbing this honorable court. Please list this matter. That will be reduced.
The petitioner is aggrieved by the manner in which his application has been dealt with by the authorities under the Right to Information Act, 2005. Stop. The petitioner intends to obtain certain information from the Chandanagar Municipal Corporation. Stop. The corporation is not represented today. Stop. Let notice be served upon the corporation or the learned advocate representing the corporation.
This is my friend is agreeable, my lord, to take into consideration all those appeal once again. Then my lord, quashing that order.
I am not agreeable. I have not said so. I have not said so.
That would be.
No, he doesn't have any objection if the corporation
Yes.
passes on the information.
I have no personal interest on
If
this.
the corporation committed wrong, my lord, supplying this innocuous, my lord, the information corporation standing on the way.
Let the
That is apparent
corporation
on the
come.
Yes.
Representing the corporation, intimating that the matter will appear in the list on 10th November 2025. Yes, sir. The information sought for by the petitioner annexed at page 43 of the writ petition be placed before this court on the adjourned date. 10 তারিখ থেকে 17 তারিখ করে দিন।
43 onwards. Number of application, my lord.
How many? 21?
But some applications are there, my lord.
No, you showed me page.
Separate premises. Other
10.
You
one I have
showed me page 43 only.
one I have shown, my lord.
Yes.
The others are
There are number of
43, 44,
That is
45.
the admitted position.
Yes, my lord. Number
Out
of
of which 10 we have disposed of 10 appeals separately.
Last line কেটে দিন। 17 তারিখ।
Let them show, my lord, 43. When they will
No,
show
no,
my lord, everything.
you have got 10 more.
Yes, my lord, number of application, there is no bar, my lord.
No bar, certainly no bar.
But
Let
once
the
again, my lord, I appreciate, my lord, the lordship memory, my lord. I mean,
thank you.
Great,
Lordship, I am appearing for the excess bank, Lordship. Lordship, may I be permitted to mention this matter only? Lordship, the matter is parting to one freeze of the account, current bank account, which is maintained by the Axis Bank Khidirpur branch. And now, Lordship, we have received the information that the account of freeze has already been removed, and now the account is operating. So, Lordship, kindly.
All right.
And this is the account.
None appears on behalf of the petitioner. Stop. The petitioner filed the instant writ petition seeking for a direction upon the Axis Bank to unblock/defreeze the petitioner's current bank account. Stop. Learned advocate representing the bank submits upon instruction that the account has already been defreezed. Stop. A freeze status maintenance by the bank has been placed before this court. Stop. The as the petitioner is not represented today, release the matter once again on 6th November. Stop. You put your learned friend on notice. Let your learned friend come. I'll dispose of.
Lordship.
All right. 6th November, under the heading to be mentioned. Give a notice. I'm keeping this on record.
I am for the petitioner. I have committed a mistake, my lord. I have served the copy of the applications upon all the respondents, but I have not served the copy of the application upon the learned government.
Who are you representing? Mobile service provider. What is your grievance?
My lord, the petitioner is the owner of that property.
Yes.
Private respondent number 6.
Yes.
7. He is with the collusion of the respondent number 6, that is mobile tower, who erected a tower in the petitioner premises.
All right.
Line. He made a representation objection before the Panchayat Pradhan, BDO, SDO, but they have not taken any steps. That's why, my lord, he
Has any objection been filed before the district magistrate?
my lord.
You have constructed the tower on somebody else's property without taking the permission. NOC by the petitioner. No, nodal officer's NOC is something else. The construction has been made over the petitioner's plot of land.
We have obtained all the permission for PAP. I am yet to receive all the papers from my client, your lordship. And besides that, lordship, there is a grievance committee for these matters, your lordship.
Yes. And the district magistrate is heading the grievance committee. All right. Please come. The petitioner alleges that the mobile service provider has constructed tower over the plot of the petitioners without taking their consent, and contrary to the provisions of law. Stop. Objections were raised before the block development officer and the Panchayat authority, but there has been no response to the same. Paragraph. Learned advocate representing the service provider.
Respondent number 6, your lord.
Respondent number 6 opposes the submission of the petitioners. It has been submitted that the construction has been made after obtaining necessary permission / sanction from the competent authority. Stop. Paragraph. As it appears that the grievance of the petitioner is yet to be redressed, accordingly, leave is granted to the petitioner to file an appropriate objection disclosing all facts and figures before the district magistrate Hooghly. Stop. In the event such representation is made, the same shall be considered by the district magistrate strictly in accordance with the relevant guidelines, after giving reasonable opportunity of hearing to all the parties and by passing a reasoned order at the earliest, but positively within a period of 12 weeks from the date of submission of the objection. Writ petition disposed. Great service taken on record. No service will be given?
No.
No. It cannot be done. Next.
422, 423, 424, 425, 426.
436, I appear for the respondent number 2, but I can give notice to the petitioner and come back on some day because this has been pending since 2024, and the last occasion also the petitioner took an adjournment. But
Are you facing any difficulty if the matter remains pending?
no
You
difficulty,
are
just
not
it can be disposed of.
Yes, yes.
Nothing-
What is the
nothing.
petitioner's prayer?
Prayer is for striking off my name from the ROC's record.
Your name.
My
You are the private
The
respondent.
private respondent.
All right. Any matter pending before NCLT?
Nothing.
No.
He owes me, petitioner owes me some money.
All
I
right.
make a demand on the petitioner for price of goods sold and delivered. The petitioner says that those demands are
That
frivolous.
is separate.
That is the grievance, and that is why he has approached the ROC for striking off my name.
All right. So you are still there in the
Yes, yes,
role of the
there's no
ROC.
difficulty if the
Stay there
Yes, very
till the petitioner moves his application.
grateful.
437,
37, my lord, I am for the petition.
Yes.
My affidavit of service. The petitioner is a senior citizen
Yes.
and he has a residence. Now he has been tortured by his elder son and daughter-in-law. The
What
petitioner,
about your younger son? He is with you. The younger son is with you.
no,
Where is,
younger son, no,
where is he?
he is residing else.
Elsewhere.
Yes,
How many children do you have?
two. Let-
The elder one is creating problems.
Yes, insisted the petitioner to transfer the residential house to his name.
Mm.
And the petitioner is not agree with the proposal of his son, therefore torture is being tortured. The petitioner
Yes.
raised complaint to the subdivisional officer.
That has not been considered.
That has not been considered and took no steps. The petitioner is passing days
Please come.
with great anxieties. That is at page
The
19.
application made by the petitioner before the subdivisional officer under provisions of the Maintenance and Welfare of Parents and Senior Citizens Act, 2007 is pending consideration since July 2024. Stop. The petitioner claims to be regularly harassed and tortured in the hands of his elder son and daughter-in-law. Stop. The petitioner fears for his life. Stop. It has been submitted that the private respondents forced and coerced the petitioner to part away with his property by signing a deed of conveyance. Stop. As the petitioner refused to sign the document at the instigation, document, the private respondents are putting pressure upon him to transfer the property in their name. Stop. Paragraph. None represents the private respondents. Stop. Affidavit of service filed in court. None represents the respondents. Affidavit of service filed in court is taken on record. Stop. Paragraph. As it appears that the petitioner is a senior citizen and application by him is pending consideration before the subdivisional officer, accordingly, the instant writ petition stands disposed of by directing the respondent number 4, being the subdivisional officer Kakdeep, to take prompt necessary steps to consider the application made by the petitioner strictly in accordance with law at the earliest by passing necessary order / direction. Stop. Steps shall be taken positively within a period of 60 days from the date of communication of this order. Disposed.
In this matter, I am ready for the petition.
Lord, the facts, my lord, the petitioner is the contractor of a enlisted contractor. My lord, the participate in a tender process. My lord, the selected in the tender. My lord, the I don't lordship's attention only one page, page 40, page 39. Annexed
Yes.
report. These my client is also my lord selected in the tender.
Page 39 is a certificate of the Gram Panchayat.
Gram Panchayat.
Yes.
This has been not certificate. This is the notice has been issued by the Gram Pradhan directing the petitioner to place the original documents.
All right. Then
Got
what
it,
else?
lordships?
Yes.
And second paragraph, আগামীকাল 1 PM এর মধ্যে গ্রাম পঞ্চায়েত অফিসে অ্যাকসেপ্টেন্স লেটার এবং সকল ডকুমেন্টস এর অরিজিনাল নিয়ে অফিস জমা দেওয়ার নির্দেশ দেওয়া হলো। After when the petitioners participate in my lord, the tender process and selected, my lord, on this date, my lord, my client could not attend the office by some hooligans. My lord, the next page 40, next.
All right. Then what happened?
My lord, that application was made before the Pradhan and the SDO, BDO, that was not taken for hearing. Now, let's say second my lord, tender has been done. My lord, the next page 41.
Yes.
I participated, my client participated in the tender process.
Hmm.
What happened, my lord? Next, your kindly page 45.
Yes.
This has been, my lord, the notice has been served.
Blacklisted.
Blacklisted.
Hmm.
When, my lord, this has been done, my lord, kindly see that to 23rd September 2024.
Hmm.
And the second tender, lordship, kindly see date, page 41, 20th September 2024. I also participated in the tender process. Now, what remarks has been done since my name has been blacklisted in the tender process, my name has been disqualified. The next page 46. My responsible submission when raised the objection before the Pradhan and the SDO that no hearing was inquiry was held, no hearing is done. The second process, since my name has been blacklisted.
Who is anybody representing the Panchayat? No.
I saw the notice.
You are for the state respondents.
Lordship, can you come to the page, paragraph 7?
Huh.
Paragraph 7 of the.
Yes.
He is a lower bidder, page paragraph 5,
No, we are not considering that, whether the blacklisting is proper or not.
Yes, he is the blacklisted,
Whether the blacklisting is in accordance with law.
Yes, in accordance with law.
Is it?
Here is the report, can you see?
No inquiry is held, no
Aren't the authority required to give an opportunity of hearing?
Blacklist, this is a tender process, my learned friend file a tender proceeding,
Page 45.
45.
This has been page 45 has been challenged.
Last paragraph.
Yes, page 45.
এই মতো অবস্থায় গত এত তারিখে গ্রাম পঞ্চায়েত সাধারণ সভার সিদ্ধান্ত অনুযায়ী আপনাকে কালো তালিকাভুক্ত করা হলো, whether this is proper or not.
And that I will take the instruction like that.
This is the legal point. You are required to give an opportunity of hearing.
Panchayat will decide.
Yes, but if
for the Panchayat
block development officer you are representing, sir, then
I shall take instruction, then come back. This is the report filed by the BDO.
Please come.
And I will
order dated 23rd September 2024, passed by the Pradhan of the Gram Panchayat, blacklisting the petitioner is impugned in the instant writ petition. Stop. It has been submitted that prior to passing the order of blacklisting, no opportunity of hearing was given to the petitioner. Stop. Violation of the principle of natural justice has been pleaded. Stop. None represents the Gram Panchayat. Stop. The learned advocate representing the state respondents relies upon the report forwarded by the block development officer. Stop. the block development officer is directed to inspect the records of the Gram Panchayat and ascertain as to whether any opportunity of hearing was given to the petitioner prior to the order of blacklisting being passed. Stop. Let notice be served upon the non-appearing respondents. Stop. Relist the matter for further consideration on 17th November.
So, Lordship, kindly come to page 49.
Action be retained with the letter.
Page 49, my lord, your Lordship, kindly come to page 49.
Okay.
Once again, my lord, serial number 4. Devabroto Sahu, 25th September, my lord, status, my lord, not admitted, free, pre-qualified and technical.
Yes, yes.
And technically, I tender one notice, my lord, they have filed, my lord, they have
Technically, the second.
The 17th November, my lord, your Lordship, if you, my lord, 2 months or 2 weeks, my lord, more, my lord, so that, my lord, I shall take instruction, my lord.
I was thinking of posting it on the 10th of November.
Oh, no.
Somebody has been blacklisted. His right to do business has been infringed.
I shall come back before your Lordship. With the
Not only instructions,
with the
proper report whether
proper report. Madam.
the hearing was given prior to passing
Yes,
the order.
take all the instruction, well, I shall come back, my lord.
Next. What is the matter?
It's actually for 39 is infructuous now at the moment.
Infructuous. Surfacy?
No question of yes, a question of repayment. First of all, compromise settlement was there.
Repayment of the loan?
Repayment of the loan.
Yes.
Compromise settlement was there. He failed to fulfill the terms and conditions, and he came to the bank. No, I'm not interested about the compromise settlement because I will be civil. I will be reporting the civil.
Yes.
So I will pay. Give me extension of
has payment been made?
Restructuring of the loan.
Payment made?
No.
No. So his civil score is going down.
Now, if he settled the account by compromise settlement, then civil will report it for as a.
Otherwise, the surface proceeding he will initiate.
That's a different. You have not yet started.
Very well.
Now, secondly, now he has submitted another compromise proposal. He is challenged this action.
So whatever, the petitioner is not here, not today only. Next one also same.
No, second one is police inaction. I think this court has not determinations.
Police
inaction. Police inactions.
Let me see.
Cybercrime is there. Some amount has been withdrawn from the bank fraudulently, whatever it may be. He's alleging that the police is not taking proper actions. The investigating agency is not taking proper actions. So direction may be given to them.
Bank and everybody is a party also.
The police commissioner, complaint of cybercrime, respond number 5, 6, 7. Alleging them that they are not doing properly. This
none appears on behalf of the petitioner. Stop. Learned advocate representing the bank submits that the matter relates to police inaction. Stop. On a perusal of the prayers in the writ petition, it appears that the petitioner has prayed for necessary direction upon the police authorities. Stop. This bench does not have determination to take up police inaction matters. Stop. Let the matter be released from the list of this bench and be placed before the bench taking up police inaction matters.
441, 442, 443, 444, 445, 446, 447, 448, 449, 450, 451, 452, 453, 454, 455, 456.
56, I appear for the defendant number 224.
Defendant?
Sorry, Your Lordship. Respondent number 224. Lordship, I have been led by Shreyan Bhattacharya. He is appearing
Yes.
online.
The petitioner is not here. So I'll
Okay.
adjourn it for the
Yes,
day. All right? Yes.
No. 459, 150, 461, 452, 463, 454, 455.
My lord, I am appearing on behalf of the petitioner.
Yes.
My lord, I am filing my affidavit of service, my lord. Petitioner, my lord, has supplied fish food and plants and fish medicine to the, my lord, as per instruction of State Fisheries Development Corporation Limited, my lord. And they have admitted my claim, but out of, my lord, 69 lakh 43,000, they have paid only, my lord, 2 lakh and something. Remaining amount is still unpaid.
Did they dispute the claim?
No.
No.
In the RTI, it is under process, my lord.
Under process. Please come.
My lord.
Affidavit of service filed in court is taken on record. Stop. None represents the respondents. Stop. The petitioner seeks payment of the due amount. Stop. Released on 10th November. Stop. Let notice be served upon the non-appearing respondents. Stop. Learned advocate for the respondent shall come ready with instruction as to why balance payment has not been made to the petitioner. Yes.
Wait.
For the petitioner. State. 456, I am for the state, my lord. 456.
Yes.
457.
No, not 456. Your other side is not there?
No.
What is the matter?
Regarding the appointment of Anganwadi.
How can Anganwadi
Lordship, it's midday meal scheme, Lordship. Let the respondent be present, Lordship.
No, by then it will be group 5 matter, isn't
No,
it?
no, no, Lordship. It is
It's not?
residuary matter, Lordship.
How can it be residuary?
Lordship, I will satisfy, Lordship.
Why are you smiling? Huh? The matter, you want to keep the matter pending?
No.
What advantage are you getting?
Not at all.
Why
Lordship,
don't you take it before the group 5 bench and get it done?
no, Lordship, that is not, Lordship. I will satisfy.
Midday meal scheme?
Lordship.
What do you want?
Should be appointment of the Samavai Samiti.
Yes.
Engagement of the Samavai Samiti.
For a midday meal
Midday meal
scheme. How can it be done in the group 9 determination? What is the name of the petitioner? কত ডাকলেন? 467.
66.
You are in 66?
66.
66 ফাইলটা 66 ফাইলটা একটু দেখি। প্রভাত মহিলা।
Lordship. No.
Your prayer is to cause immediate investigation over the representation preferred by the members of the petitioner society for providing midday meal. This particular is 105 to take necessary action in response to the representation filed. You have a copy of the brief today?
Not yet.
মিড-ডে মিল রান্নার জন্য নিয়োগ করার প্রার্থনা। To the Sub Inspector of Schools, District Project Officer, DPO, সর্বশিক্ষা মিশন, Coordinator of the সর্বশিক্ষা মিশন। I have great doubt that this matter can be taken up in the Group 5 bench. The respondent is the Secretary of the Education Department, the School Education Department, the Sarva Shiksha Mission. Please come. The matter relates to appointment of the petitioner in midday meal schemes. Stop. This court does not have the determination. This bench, likhun. This bench does not have the determination to take up the issue. Stop. Let the matter be released from the list of this bench and be placed before the bench having determination. Stop. Leave is granted to the advocate on record of the petitioner to amend the presentation form and the front sheet of the writ petition. Change it, otherwise it will not go. Any other matter?
Well, item
Yes.
474. Your lordship is called, then I can take it up.
All right. Very well. Dakun dekhi.
468, I am appearing for Reserve Bank of India, respondent number 1 in the matter.
All right. Next.
471, I am appearing on behalf of the petitioner.
What is the matter?
Also, freedom fighters pension. Your lordship's usual or your lordship's can.
I led by Lord ASG, my lord. He has requested me to pay for not this week, my lord.
Not this week.
My lord,
all right.
Then fourth lordship kindly, not
Then?
Tuesday, lordship.
Tuesday?
Lordship.
Actually, get into release the matter on 4th November 2025 on consent of both the parties.
Lordship. Get full.
I appear for the respondent number 3 and 4, your lordship, in this matter.
It's being adjourned for the day.
Lordship.
My lords, I'm appearing on behalf of the petitioner, Apollo Multi-Speciality Hospital, my lord. We are challenging 2 orders of the West Bengal Clinical Establishment Commission, my lord, wherein the order only records that the matter pertains to insurance domain. Your lordship kindly comes to the order. It's very crystal clear, my lord. As because the insurance has not paid the money, the hospital has been asked to put the amount in the fixed deposit, my lord.
Right.
And wherein ombudsman has also rejected the prayer of the petitioner. Actually, the authority is the ombudsman, insurance ombudsman. Lordship comes to page 27.
All right. None represents the respondents. Stop. Let notice be served upon all the respondents. Released on 10th of November.
Well, I have a of service. Now
Yes, service is taken.
Again,
over.
7 come back.
Yes.
Grateful and deeply honored.
Which matter?
My lord, item 480, my lord.
Ah.
The division of 2 courts, that the Purbo Bardhaman and Paschim Bardhaman. We are for the bar of Purbo Bardhaman. After division, some police stations are required to be segregated, but it is yet to be segregated, and the records are not also coming. So the bar association of the Purbo Bardhaman, they are suffering, my lord. There is a recommendation from the judicial department that it has to be done very short, but it is yet to be done, my lord. It's a very short matter, my lord.
480.
480, my lord.
None for the respondents. 480 record and order, please. Release the matter on 4th November.
Well,
Stop. Let all the respondents be notified.
I'm grateful, Lord.
My lord, 479, lordship, I am for the petitioner.
What is it?
My lord.
1 minute. Budhu Dakun to dekhi. 475.
475.
Next.
476, my lord, I am appearing for bank.
All right. Next.
477. 478. 479. 479. Lordship, the petitioner is the wife of an army person, lordship. Lordship, the petitioner, after getting married, was passing her days happily, lordship. But after few days, the husband of the petitioner stopped giving any maintenance and keep contact with her and her 2 daughters, lordship. Lordship, the petitioner filed application before the authority, and authority, lordship, asked her to give to submit some document for getting the maintenance, Lordship. Lordship, as per the direction, as per the requirement of the authority, Lordship.
Will the writ petition be maintainable?
Yes, Lordship.
How?
Lordship. Lordship, kindly. Lordship, kindly see the communications, Lordship, kindly once. The authority communication page, Lordship. Once. Page 21, Lordship. And
Is your husband still in service?
Lordship.
Is your husband still in service?
Yes, Lordship.
Why don't you go before the proper forum? Does the writ court have the determination to pass any order upon this army personnel?
No, Lordship. There is a provision where the authority can deduct the maintenance, deduct the amount from the salary for the deprived family, Lordship.
Absolutely. Go there before the proper forum and get this order.
Lordship, kindly see, Lordship, once, Lordship, last communication, Lordship.
What will the court do
Lordship,
looking at this
only,
document?
Lordship, the authority, they are saying that it is not correct to pending this matter for such a long period, Lordship. And I have filed a representation, Lordship.
Please come. The petitioner claims to be the wife of an army personnel. Stuff. She has certain private grievances against her husband. Stuff. She prays for a direction upon the respondent army personnel to deduct a portion of his salary and credit the same in the account of the petitioner for her maintenance. Stop. Paragraph. None represents the respondents. Stop. I am afraid that the prayer of the petitioner cannot be entertained by the writ court. Stop. Next. The husband of the petitioner is in the army, and all communications annexed to the writ petition are against army personnel. Stop. It will be open for the petitioner to approach the competent forum for relief in accordance with law, if so
Lordship,
advised.
Once, Lordship, last communication. Once, Lordship, kindly see P3, Lordship. Once see, Lordship.
Page
47, Lordship.
Yes.
It is submitted for your information that, Lordship, in between the authorities, Lordship. Lordship, kindly.